Okay, can we resume? Both sides. Okay. So let's get started. Now we have the opening presentation of claimants. We will go through 2:30, then we have a break around 2:30, the vicinity of it. And then you have additional 60 minutes to go. Okay?
Thank you, Mr. President.
So the floor is yours.
Thank you, Mr. President. Slide 2, please. Is that better?
Yes.
Just trying not to yell.
Yeah, it doesn't do it for us. It doesn't do that.
What do we?
It didn't do it for ours either. Okay. Yeah. Yeah. Thank you.
Okay. Now that we've got the technical issues out of the way. And so thank you, Mr. President. The slide before us describes how we will address the opening issues, addressing the case as pleaded and addressing the issues in the context of the case as pleaded. We begin by discussing the standard of review for this proceeding in accordance with the rules and in accordance with the agreement of the parties. We briefly address the question of non-party submission of the United States. And we will address, and I'll actually ask my colleague, Mr. Conrad, to address the factual background here, because that's the necessary context. And I have to say, with all respect, what we didn't hear about this morning for this case and this application, we'll describe the violations of the TPA as pleaded, address the question of our damages, address the various jurisdictional objections that have been made, and then conclude, hopefully on time, Mr. President. So if we could have slide 4, please. Mr. Conrad will describe this in more detail, but the procedural history here, very briefly, is this. In 2009, Reficar, a wholly owned subsidiary of Ecopetrol, which in turn is owned by the Ministry of Finance of the Republic of Colombia, and FPJVC, not the individual members, entered into a contract to provide specified services in connection with the upgrading and modernization of a refinery in Cartagena, Colombia. But very shortly after that contract was entered into, Reficar, exercising its rights under an express term of that contract, radically changed the scope of the joint venture's work. And in effect, as we will describe, made FPJVC essentially a provider of personnel to what Reficar referred to as an integrated project management team, and critically deprived FPJVC of any authority over the expenditure of public funds, either to prevent the expenditure or to authorize the expenditure. FPJVC completed its work under the contract. It invoiced for that work. Each of those invoices was paid by Reficar without objection. Nonetheless, the CGR then went and initiated fiscal liability proceedings against the claimants and a host of others, arguing that FPJVC, actually the members of FPJVC, were fiscal managers, which is a specific defined term under the Colombian statute, Law 610, that creates the CGR and under which the CGR operates. And that requires that a fiscal manager have authority, as we have repeatedly pleaded and as we have shown, over the expenditure of public funds, and that it, in order to incur liability, that it must act with, at a minimum, gross negligence. Although the claim, despite its length, essentially asserts a breach of contract at most against the claimants. The claimants did give notice. The record shows that Colombia ignored that notice of an intent to bring a claim, refused to engage at all. After the cooling off period had expired, the claimants reached out again to Colombia, pointing out that they now were free to bring a claim, but again, inviting Colombia to meet and attempt to resolve this matter. And this time, Colombia did respond. And representatives of the claimants, both counsel and business personnel, traveled to Bogota and met with Andaje, the governmental agency represented here today, which has authority over investor state claims in Colombia. Those discussions were fruitless. And after those discussions failed, this arbitration was initiated. Slide 5, please. So the TPA itself addresses the question of preliminary questions. The language is before us. And I don't think it's seriously disputed that, perhaps not disputed at all, although it wasn't entirely clear to me from this morning's presentation, that on preliminary questions, the allegations of the request for arbitration are to be taken as true, and that preliminary questions are not intended to resolve factual disputes. They're not intended to resolve mixed questions of fact and law, virtually all of the issues that were highlighted this morning, or complex questions of law. It's in effect intended to weed out claims that clearly show on their face that they don't come within the terms of the treaty. Next slide, please. And the tribunal will recall the discussions leading up to procedural order number 1. I don't think we have to spend a great deal of time talking about who said what about this. The procedural order does speak for itself. But this is what Colombia said about how we came to be here. And that is that the tribunal, the only point at issue is whether the tribunal will establish a calendar to hear solely respondents' Article 1024 objection as a preliminary matter, or whether it will establish a calendar to hear both respondents' Article 1024 and respondents' other jurisdictional and or admissibility objections as preliminary questions.
Excuse me, I'm sorry to interrupt.
They went on, if we could have the next slide, please.
We can't see the slides.
As reflected in procedural order number 1, that it was without prejudice to its objections to jurisdiction and or admissibility. On the next slide, number 8, we highlight the particular provisions of PO number 1 that govern this proceeding. And the tribunal will recall that we had actually proposed, Claimants Counsel had proposed a jurisdictional phase in which, as in any jurisdictional phase, there would be a full development of the factual record, because jurisdiction typically turns on questions of fact or mixed questions of fact and law. And that was actually objected to by Colombia, saying there was no need for disclosure because these would only be questions of law. And now we're told that there's a burden of proof on facts on claimants when that is the exact opposite of what was agreed. This was going to be done as a consolidated preliminary matter addressed to questions of law raised by the RFA. And I should say at the outset that all the cases that were referred to this morning about jurisdictional dismissals were in jurisdictional phases of cases. The tribunal certainly knows that it's not at all uncommon in investor state claims for there to be a separate jurisdictional phase in advance of a hearing on the merits. And sometimes those do result in jurisdictional dismissals. What wasn't provided, because so far as I know, it doesn't exist, is a jurisdictional dismissal in effect on briefing and oral argument addressed to a pleading. And certainly none was cited to us this morning. So it is true that as the claimants, we bear the burden of proof ultimately to show jurisdiction. We couldn't contradict that, but that is on a full record. The case was not bifurcated into a jurisdictional and a merits phase. The case was not trifurcated into a preliminary objections, a jurisdictional and a merits phase. It was on the request of the respondent, set up as preliminary questions. And if they failed on those, as they should, as they will, that there would be a merits phase at which they will be free to raise any and all jurisdictional objections that they choose to raise. But that will be on a full record with the benefit of disclosure, with the benefit of witness testimony, with the benefit of a full developed record, as should be the case for any attempt to terminate a case. Slide 10, please. And slide 11, there we are. So this is the language of the treaty regarding hearing on preliminary questions, claimant's factual allegations in support of any claim in the notice of arbitration must be assumed to be true. Although we heard repeated challenges this morning to the truth of those various allegations, and I'll turn to some of those later in our presentation. But next slide, please. This is not an evidentiary hearing. Although Colombia has repeatedly attempted to turn it into one. Here on slide 12 is an example. Or two examples. Claimants, we have not proved that there is a lack of effective or sufficient means or remedies against the ruling with fiscal liability, or that such remedies are futile, ineffective, or improbable. Well, that's because we haven't had a hearing yet on that. But we pleaded that because, particularly in light of the extraordinary delays, a decade or more, that plagued the Colombian judicial system. And we're not just making this up. As the Tribunal will recall from the hearing on interim measures, the former chief legal officer of the CGR provided a witness statement detailing exactly the difficulties that we would encounter in seeking relief. But the allegation here, it's a well-founded allegation. It is either a question of fact or a mixed question of fact and law. It is not a question of law, as was asserted this morning. Similarly, we hear that claimants in paragraph 204 of the reply that was filed by respondents. Claimants assert they have suffered reputational damage as a result of the alleged violations perpetrated by Colombia. Indeed, we do. And indeed, we did. But they have failed to prove, even prima facie, the existence of such damage. If this were an evidentiary hearing, we would call witnesses to precisely that effect. But that is not how this was set up. That is not how this part of the proceeding is organized. And it is inappropriate to suddenly shift gears and assert that there's an obligation to come forward and prove these allegations on a hearing intended and designed to hear preliminary questions. And so on the next slide, 13, we cite from the decision in PAC-REM versus El Salvador, a widely cited case in which the tribunal will recall Mr. Viter sat as the president of the tribunal. And he in turn citing Professor Schroer and his commentary on the ICSID convention states that talking about saying no proof is required at this stage. On most points, a mere assertion in the request will suffice, and the information thus given may be developed at a later stage. By assertion, the tribunal assumes these authors to mean an appropriate statement specifying the factual and legal bases of the claim without evidential proof. The following slide, number 14, discussing CAFTA, which in this respect is materially identical to the Colombia-US TPA, makes the important point, which I think has been elided by Colombia, that the procedure under 1024 is clearly intended to avoid the time and cost of a trial and not to replicate it. There can be no evidence from the respondent contradicting the assumed facts alleged in the notice of arbitration, and it should not ordinarily be necessary to address at length complex issues of law, still less legal issues dependent on complex questions of fact or mixed questions of fact and law. But that sort of mini trial in advance of the development of the record is precisely what Colombia is attempting to create here. From the Capis case in the next slide, cited this morning by Colombia, makes it clear that if there were any deficiencies identified, we can, in fact, clarify and submit them. And I should say at the outset, as the case goes forward, we will, of course, amend it because there is now an award of the tribunal, which we were told at the hearing on interim measures they intend to enforce and are making efforts to enforce. Depending on the exchange rate in effect, somewhere between $750 million US dollars and $900 million US dollars. So of course we will address that as the case moves forward. But the point here is that by making this application on preliminary questions, Colombia in effect froze the case in time, because that application, as we were told this morning, properly so, is addressed to the RFA as pleaded. And that will withstand this application, as we will show. But that doesn't mean that that is the case that will ultimately be heard by the tribunal. Everybody knows that as circumstances develop, cases change, that claims are amended or supplemented, and obviously it's a very significant development. And I should say at the outset, there was a lot of discussion about how this is somehow a moving target, and there was a quote put on the screen, and that the measure being challenged was the CJR decision in response to a question asked by the tribunal at the interim measures hearing. Well, that was at the interim measures hearing, and the question was, what measure were we challenging there? The question, and I answered it, at least as I understood it, and as the record shows was the case in context, was not what is the measure being challenged in the RFA. There's no contradiction there. The case is not a moving target. The case is as pleaded, and it's as pleaded precisely because Colombia chose to make this application prematurely. If they wanted to raise these questions, which are questions of fact or mixed questions of fact and law, they should have done it in an appropriate way, either seeking a separate jurisdictional phase, which they expressly disclaimed in the negotiations leading up to, or the discussions leading up to the issuance of PO number 1, or applied for that by agreeing to treat everything in their words as preliminary questions, whether they are preliminary questions within the meaning of the treaty or could otherwise be considered on a factual record. The decision was made to put them in that particular procedural context governed by PO number 1, and they should be held to the bargain that they made. And along those lines, again, as PAC-RIM makes clear in slides 16 and 17, if we could have, we do have them up. The tribunal should not take a formalistic view of a pleading. This isn't some 18th century common law court where exact wording is the sine qua non of jurisdiction or on the merits. Particularly in considering preliminary objections, it is not appropriate to take a strictly formal and formalistic view. So as slide 18 makes clear, the burden of proof, well, the respondent attempts to place the burden of proof at this stage of the case on claimants, but they're conflating the ultimate burden of proof in the case, which we don't dispute rests on the claimants. The claimants, as claimants, must prove each and every element of their claim. Could we have slide 19, please? So 17, 18, and 19 consist of quotes from the papers submitted by Colombia, all attempting to raise factual issues, all suggesting that there's a burden of proof on the facts at this stage in the case on claimants. That's not the law. It's not procedural order number one. And it would be, I have to say, a miscarriage of justice to suddenly switch ground at this point in these proceedings and assert that claimants bear some kind of burden, let alone the final and ultimate burden of proof on these factual issues. Could we have slide 21, please? This is a quote from, excuse me, the PAC-RIM decision, making it clear that the burden of proof at this stage of the proceedings rests on the respondents to show clearly and convincingly to a certainty, in the words of some tribunals, that there is no case and that they cannot show. We also refer to Bridgestone versus Panama, where the tribunal stated at all times during the exercise under CAFTA Articles 1020.4 and 1020.5, the burden of persuading the tribunal to grant the preliminary objection must rest on the party making that objection. And indeed, in our field, in international arbitration, the burden of proof is always on the party asserting a fact, a claim, or a defense. And that is Colombia at this stage. If we could have slide 22, please. Specifically with respect to the burden of proof on jurisdictional objections, about which we heard so much this morning, Colombia cites a line of cases, but all of those cases arose in the context of decisions on jurisdiction in the jurisdictional phase of a case, not on preliminary questions, whether under Article 1020.4 or under ICSID Rule 41. And as I've already noted, that is not the position that Colombia took in the discussions leading up to procedural order number one. And it is certainly, had it been the position, we would have objected as strenuously as possible to having a hearing on the merits, some sort of mini trial or preliminary trial before the record was developed. We'd have slide 23, please. I'm sorry? Yeah. And this again is from the respondents saying it is worth noting that respondents' position is that document production, which of course would be necessary to a hearing on the merits, on the facts, will not be required during the preliminary phase because the issues discussed will turn mostly to legal questions. And if we could have slide 24, please. This is how the tribunal resolved that issue and ordered that the case proceed. And those are the paragraphs that bring us here today. And if we could have slide 26. It's, again, from two decisions, RSM versus Grenada, and again, the PAC RIM decision, both by distinguished tribunals. Under ICSID Rule 41.5, an alternative source of authority here, a tribunal should only dismiss if it finds that the claimants are certain to fail.
Mr. Sills, for the record, you said slide 26, that you mean 25, don't you?
I did. Thank you. Thank you, Mr. Beeching. I'm getting ahead of myself.
Don't worry, I am listening.
Let me turn very briefly to the question of the non-disputing party submission about which we heard so much this morning. First, as it always does when it makes a non-disputing party submission, the United States expressly disclaimed expressing a view on the merits of the case. And it is concerned largely with theoretical and somewhat abstract questions of law, largely referring to the treaty itself and to the views of the United States on that treaty. But if we could have slide 28, please. Colombia takes the view that this non-disputing party submission is arguably more important than other arbitral decisions or jurisprudence, and actually claims that it represents a subsequent agreement or subsequent practice under Article 31 of the Vienna Convention. This morning's transcript shows that that non-disputing party submission shows, quoting from the transcript, the highest possible degree of agreement. One would think that the highest degree of agreement would be an amendment to the treaty. But the position that Colombia advances here, that the US submission is binding authority here, has been rejected repeatedly by ICSID and other tribunals hearing investor claims. If we could have slide 30, please. This is a quote from the decision of the tribunal in Telefonica versus Argentina. They are not evident, these non-disputing party submissions are not evidence of subsequent agreement. They don't evidence subsequent practice. They can't be evidence of subsequent agreement because non-party submissions are a unilateral act. A subsequent agreement requires the parties to come to an agreement in a single common act, an amendment to the treaty, for example. And the interpretation being offered this morning would simply blur the distinction under the Vienna Convention between under Articles 31.3a and 31.3b of the convention. And no case has been cited in endorsing the notion that a non-party submission constitutes a subsequent agreement. They're also not evidence of subsequent practice because subsequent practice depends not on a single instance, but on whether and how it's repeated. And a single instance of common conduct, even if a non-disputing party submission was such evidence, is not dispositive for treaty interpretation. Although it is asserted to be. But I think more important, this is an amicus submission. It's an amicus submission that's entitled to the weight that its logic and reasoning and authority cited carries. And it's for the tribunal to decide how much weight to give to a non-disputing party submission. It is not true that simply by filing a statement on an amicus basis to which another party will agree that it suddenly becomes a binding agreement. There is no authority for that. The Vienna Convention, after all, says only that the tribunal should take into account a non-disputing party submission, not that its hands are tied or that it's somehow bound. Now, some treaties do have a mechanism for the state parties to the treaty. NAFTA, in its original form, for example, set up a mechanism where the parties, through a formal procedure, could agree on a binding interpretation, but that's simply absent here. And I have to say, with respect to the United States, the submission made here consists largely of a series of ipsedixits, assertions about the law without reference to the decided cases, without reference, for the most part, to significant jurisprudence, and taking a view that the United States, for its own reasons, and as we suggest as a state party, the US has an interest, it's not purely a disinterested party, would take. But it's for the tribunal, as all the tribunals cited in our papers and in these slides have dealt with non-disputing party submissions, not only by the United States, but by other state parties, and for that matter, private parties. Those submissions get the weight they deserve, and it's for the tribunal exercising its discretion and weighing those submissions against the body of decided cases and against the jurisprudence that everyone follows to decide whether to give any weight to that submission, and if so, how much weight to give to that submission. So with that, and I do note, just finally, Colombia relied heavily this morning, relied heavily in its papers on non-disputing party submissions, but it's a closed loop. And they are presumably relying on those because they cannot find decided authority in their favor, because they cannot find jurisprudence supporting their positions. But those are amicus submissions. And as I say, they have the weight they deserve. And it's for this tribunal to decide how much weight to give that submission in this case, as will become clear in a moment from Mr. Conrad's presentation, to the extent that there are assumed facts underlying the submission of the United States. They are based on an incorrect reading of the record here, and in particular, the statements of the United States regarding the burden of proof took no account of the procedural order that actually governs here, or the discussions leading up to it, and simply relied on abstract statements about who bears the ultimate burden of proof on jurisdictional issues, a point that I don't believe is actually in dispute here. With that, I'll ask Mr. Conrad to describe the factual background of the dispute.
Thank you, Mr. Sills, members of the tribunal, opposing counsel. I wanted to start out with the slide here that goes through kind of some of the chronology of claimants' investment in Colombia. This began in 1975 when claimants began investing in Colombia. Over those years of almost 30 years, it wasn't until 2004 when Ecopetrol began planning this mega project known as the expansion and revamp of the Cartagena refinery in 2004. Subsequently, in 2007, Ecopetrol, which Mr. Sills stated earlier, is 100% owns an entity called Reficar, and it created Reficar in 2007 for this very purpose, to own this refinery and subsequently operate this refinery. Ecopetrol is owned by Colombia of 88%. It's a majority owned, 88%. And that those shares are actually owned by the Ministry of Finance of Colombia. Colombia also owns all the hydrocarbons, which are managed by the National Hydrocarbons Agency, and Ecopetrol and Reficar carry out many of the National Hydrocarbon Agency's duties. In 2009, Reficar entered into a contract, which we heard about this morning from Colombia's counsel, which I will go into a little bit more detail here during this factual background section, but entered into a contract called the Project Management Consultancy Agreement or Contract, or the PMC Agreement. This contract specifically contemplated project management services for the construction of a mega project refinery. I mean, this was a multi-billion-dollar project upon which Ecopetrol, through its wholly owned subsidiary Reficar, contracted with Foster Wheeler to provide these project management services related to this construction mega project. In that agreement, it contemplated delegation of authority. Essentially, what was contemplated by the agreement as it was signed and executed back in November of 2009, there was an appendix to that agreement that outlined all of the specific obligations contractually that Reficar expected Foster Wheeler to perform. Many of those agreements, or many of those duties within that agreement, contemplated that Foster Wheeler would effectively serve as the owner's representative, be the face of Reficar vis-a-vis Chicago Bridge and Iron, who had been selected as the engineering, procurement, and construction contractor, or in other words, the general contractor. But what was contemplated that Reficar would hire a PMC, and a PMC is not unusual in mega projects such as this one, as far as the setup. From 2009, again, November, when the PMC contract was first signed, that agreement lasted for the better part of almost a decade. It went from 2009 till the end of 2018. It was a long-term agreement upon which Foster Wheeler was performing services. Next slide, please. And in our request for arbitration, which is excerpted here on slide 33, it specifically refers to additional investments that claimants made in Colombia. It wasn't limited just to performing this long-term construction project management services contract on behalf of Reficar. It also incorporated or included the specifically investing significant amounts of time, capital, personnel, and labor in the Colombian territory. And in that regard, there were two, as we all know, there are two entities that comprised of the contractual joint venture, Amec Foster Wheeler USA, and also Process Consultants, Inc. Process Consultants, Inc. formed a local Colombian branch called PCIB, which performed the local work, performed the local labor. Amec Foster Wheeler performed the offshore work. So there was, and claimants have pled that there are significant amount of investment locally in order to perform that work, not just the work that was contemplated within the contract, but also in order to do that work, they expended significant time, significant capital, hired personnel, paid taxes in Colombia. Before I turn to the next slide, Tribunal, the next slide contains confidential information. I just wanted to advise the Tribunal.
If you can give us 1 minute.
Of course. Yeah, thank you, Madam Secretary. The next slide is just a excerpt of a section of the PMC contract that specifically contemplates that Reficar here, this last or the second paragraph that's excerpted here says that Reficar may make the decision at any time whether to continue or not all or any part of the services included in the offer. Next slide, please. As I stated earlier, in November of 2009, this contract, as written and as contemplated by the claimants here who signed it and agreed to perform it as written originally, changed almost within 30 days of after signing it. At the first kickoff meeting between Reficar and FPJVC, Reficar informed FPJVC that they were no longer going to be serving the role as a traditional PMC. Instead, Reficar decided to create what they called an integrated project management team. But really, in reality, it was really just Reficar's project management team with Foster Wheeler providing support. On slide 36 here is an excerpt from the Jacobs report. Jacobs is Jacobs Consultancy. It's a well-known EPC contractor, very similar to Foster Wheeler, very similar to CB&I. It's a competitor to both of those companies. Jacobs was retained by Ecopetrol to serve as its basically eyes and ears to report to Ecopetrol, who's the 100% owner of Reficar, to basically audit and supervise and check in and report to Ecopetrol about the project's status. In October of 2015, well after the project had been, started in 2010, but basically at the time of the project's construction completion, but prior to the pre-commissioning and startup of the refinery, Jacobs issues a report to Ecopetrol. This is what's shown here. And specifically in paragraph 1, Jacobs found that an integrated project management team, PMT, the authority and responsibility for decision-making must be delegated in specific positions within the organization, and these positions should not be duplicated. This was not so in the Reficar project, and all of the decisions had to be made by only Reficar managers. Foster Wheeler's team had no authority and became only additional personnel in Reficar's team, and many of the management functions were duplicated. Without having any authority, Foster Wheeler's personnel could only make suggestions and provide tools for project management. All of the decisions had to be made by Reficar's managers. Despite having received or this report been issued in October of 2015, the Controller General, who's the most senior person within the Controlleria, orders a special audit in December of 2015, just a few months later. After that, in May, shockingly, the Controller General makes public statements about Foster Wheeler's management control was, quote, shameful and embarrassing. Thereafter, the final report on the special audit was issued in November of 2016, and then on March 10th, 2017, the CGR commences its fiscal liability proceedings based on Law 610. In this opening resolution, which is March 10 on page 37, before I move to page 38, notably the CGR, and I don't think that Colombia mentioned this in their proceeding or their discussion earlier, they did not charge Ecopetrol. They did not charge Reficar. Who did they charge? They charged certain officers and directors of Reficar. They opened with an investigation with respect to the directors and officers of Reficar and the directors of Ecopetrol, along with Foster Wheeler and CB&I and several insurance companies. Next slide on 38. On February 2018, Claimants, Foster Wheeler USA, and PCI submitted in English, the translation is free versions. What were these free versions? These were opportunities for the claimants to explain to the CGR that there is no liability here. We are not fiscal managers. Claimants attached the Ecopetrol Jacobs report as evidence to the Controlleria, along with other evidence that the claimants submitted to the Controlleria. Despite that fact, on June 5th, Auto 773, the charging document, or as Colombia stated in its papers, the indictment order was issued. So despite having all of that evidence and proof conclusively showing that neither of the claimants or none of the claimants were fiscal managers, they charged them. In that same document, they charged them with $2.43 billion worth of damages. The entirety of the amount earned, gross revenue, was just shy of $270 million. This project cost total over $8 billion. But the charge here was a multiple of almost 10 times what claimants had been paid on this contract at the time of June 5th, 2018. In this same document, Auto 773, the Controlleria also dismissed charges against the Ecopetrol board members, finding that they didn't have ultimate decision-making authority. They were not fiscal managers, which is exactly the same argument that the claimants had presented to the Controlleria in its free version, and that the Colombian government through Ecopetrol had within the Jacobs report of October of 2015. That decision to the memorializing that dismissal of the Ecopetrol board members was made on August 5th, 2018, as shown here on slide 38 in Auto 188. Thereafter, the claimants filed a tutela with seeking basically to whatever they could to try to seek dismissal of the Controlleria's proceeding under asserting violations of Colombian law only. And it was dismissed. Thereafter, claimants submitted their notice of intent in December of 2018. And as Mr. Stills stated earlier, between the submittal of the notice of intent, there were meetings taking place where claimants sought to potentially resolve pursuant to that notice and the cooling off period. Those discussions were unsuccessful, and claimants filed their request for arbitration in December of 2019. The last few slides here are subsequent to the request for arbitration filing, but they deal with the ongoing defense that are related to claimants in a proceeding that they didn't begin. It's a proceeding, the Controlleria's fiscal liability proceeding, to be clear, was instituted by the Colombian government, specifically the Controlleria. This was not a proceeding that the claimants instituted on its own. These actions of the tutela were limited to technical issues related to the defense, seeking the right to cross-examine technical experts on the first occasion, and the other one seeking additional time to file their responsive or motion to reconsider of this internal appeal within the CGR. All again, no external proceedings, no commencement of any new proceedings. And then ultimately, in April 26 of 2021, the CGR issues its decision, finding claimants, along with others, except for the Ecopetrol board members who had been dismissed, jointly and severally liable for, at then, $811 million based on the rate of exchange. And then subsequently, on July 6, 2021, the CGR decision became final. Where are we now? Just most recently, after our provisional measures hearing back in November, Colombia has begun its collection efforts. The collection proceeding is now commenced. We received notice of a persuasive collection. As Colombia mentioned earlier, that's an opportunity for the claimants to voluntarily make a payment. And then after that, as we described at the provisional measures application hearing, there will be a forced collection proceeding commencing now. This concludes the section on the factual background. I'll now turn it back to my colleague, Mr. Sills, to discuss respondents' prima facie violations, objections, as preliminary questions to the TPA. Thank you.
Thank you. If we could have slide 42. These are the 5 claims pleaded to date in the RFA. And I'm going to go briefly through them in turn, beginning with the violation of Article 10.5 of the treaty, the minimum standard of treatment. Slide 44, please. Slide 44 requires Colombia to provide claimants with fair and equitable treatment that specifically includes the customary international law minimum standard of treatment of aliens as the minimum standard of treatment, and goes on, of course, to provide in paragraph 2 that FET includes the obligation not to deny justice in civil, criminal, or administrative adjudicatory proceedings, and then makes itself subject to Annex 10A. Slide 45, please. Annex 10A states that the customary international law minimum standard of treatment of aliens refers to all customary international law principles that protect the economic rights and interests of aliens. Slide 46, please. The RFA pleads at least 6 particular grounds for concluding that the treatment of claimants fell below the minimum standard of treatment. Those are, first, that the CGR concluded without any possible basis that claimants were fiscal managers and asserted jurisdiction in the fiscal liability proceeding on the grounds that they were, in fact, fiscal managers who had engaged in gross negligence, although, as we have pleaded, as Mr. Conrad has just described, very early in the process, Foster Wheeler, the joint venture, had been reduced to providing personnel to Reficar, which determined to manage its own project, and that the joint venture had no authority over the expenditure of funds, no ability to stop the expenditure of public funds, and could not possibly have acted with gross negligence. Second, the CGR failed to articulate or give proper notice of viable theories of liability, causation, and damages. It was simply asserted in this enormously long charging document that all respondents were jointly and severally liable for all damages. The damages, essentially, the difference between the bid price as estimated by Chicago Bridge and Iron, not by FPJVC, and the amounts that were ultimately incurred in order to complete the project. Those damages not only were joint and several, but they were grossly disproportionate to claimants' alleged harm, and there was no attempt to establish a causal link between any wrongful act of FPJVC, or for that matter, other defendants, and any damages alleged to have resulted. And of course, the tribunal will recall that in the Glencore case, an irrational damage theory adopted by the CGR was the basis for liability found by the tribunal in that case. And Colombia also took, through other agencies of the Colombian government, conflicting positions on this. The Jacobs report was specifically endorsed by the PGN, and that is the Jacobs report as commissioned by Ecopetrol, the owner of Reficar, the owner of the project. We plead that we were not afforded an adequate opportunity to defend ourselves. And as Mr. Conrad just described, the CGR, supposedly a neutral decision maker of the Colombian government, repeatedly made inflammatory statements impugning the integrity of the claimants here, asserting that their fiscal management, which didn't exist, was embarrassing or shameful, publicizing, waging a campaign in the press against the claimants, and resulting, as we plead, in reputational harm. If we could have slide 47, please. This slide puts up in graphic form Colombia's objections regarding the FET claim, and as we'll show in a moment, putting to one side that they're entirely unfounded, they're certainly not appropriate for consideration as preliminary objections. As I was describing before, preliminary objections deal with straightforward legal questions so that the tribunal doesn't have to make factual determinations or resolve complex issues of law. Here, Colombia raises questions about the content of the FET standard. In fact, this morning, I believe they made an attempt to resurrect the near standard of, I guess it was 1923, as to the minimum standard of treatment. And thankfully, the minimum standard of treatment has evolved well beyond that. Mixed questions of law and fact, to choose only one of many examples, whether claimants have adequately exhausted local remedies on the denial of justice claim, or for that matter, whether there is a meaningful and effective remedy at all. But to the extent the tribunal, and these should not be addressed on preliminary questions because it's simply inappropriate in the procedural posture in which the case is now to resolve those questions, even to address them. But to the extent the tribunal does decide to address any of them, Colombia is wrong on the law. Slide 48, please. The first of the objections Colombia has raised that I want to address is the notion that the treaty protects investments but not investors. Now, as the quoted language on on slide 48 makes clear, the FET provision states that it means the customary international law minimum standard of treatment of aliens as the minimum standard of treatment. Aliens are investors. Aliens are not investments, and there is no way to construe the term investments to include the term aliens. Similarly, Annex 10A, which is a part of the FET standard as it's defined by the treaty, states that it refers to all customary international law principles that protect the economic rights and interests of aliens. Slide 49, please. This is an extract from the decision in Lyon versus Mexico. We heard a great deal this morning about Lyon versus Mexico because a colleague of mine, not a member of the team on this case, was counsel for Mexico in that case. And the case under NAFTA is distinguishable in many ways, but something we didn't hear this morning is that the positions being ascribed to our firm were rejected by the tribunal in that case. And I understand why an attempt was being made to suggest that we were taking contrary positions, but it's parties that take positions, not law firms. And the fact of the matter is the NAFTA tribunal in Lyon specifically rejected the argument that investors were not protected by essentially similar language in NAFTA. The language is here on slide 49. But this is not an anomaly. Other NAFTA tribunals that have rejected this precise argument are cited in our rejoinder at paragraph 72. They include GAMI versus Mexico, Chemtura versus Canada, Maryland Ring versus Canada, and SD Myers versus Canada, each of which rejected this argument. And there is no case of which I'm aware, and no case that's been cited, where an FET provision, where a claim was rejected based on the notion that the treaty in question protected only investments and not investors. I have to say, it seems like a somewhat artificial distinction in any event. It's, after all, investors who make investments, and the notion that investors are protected, but not the investors who make those investments, I've always found difficult to follow. Nonetheless, these other tribunals have rejected that claim as well. Could we have slide 50, please? Here on slide 50 is a quote from the decision in Bagat versus Egypt. And the tribunal did describe why they were rejecting this argument, saying measures against an investor or the management, or measures deteriorating circumstances. Sorry.
You're reading it right. It's rather strange English, but you're reading it right.
That's what gave me pause there, Mr. Beach. Which were favorable for the investment may equally have a negative impact upon the investment. It would reduce the effectiveness of the system of investment protection system if it would only prohibit limitations to the flow of capital or infringements of property. It probably read better in the original. Turning next to the question of the substantive standard itself, there was reference again this morning to NEAR. I don't think we need to spend a lot of time on this. I think it's common ground, or at the very least should be common ground, that ever since the NEAR case, which was decided just under 100 years ago, and involved, as I recall, the failure to initiate criminal proceedings involving a murder in Mexico, the standard of treatment to be afforded in international law has evolved well past that, in particular through the very dense network of investment treaties, bilateral and multilateral, that have come into being since then. For example, in the Azurix case cited on slide 51 here, the minimum requirement to satisfy this standard has evolved, and the tribunal considers that its content is substantially similar whether the terms are interpreted in their ordinary meaning as required by the Vienna Convention or in accordance with customary international law. The next slide, page 52, has a quote from Professor Paulson's widely cited article. And in fact, I don't think that the academic debate over the source of the standard of treatment, whether autonomous or not, really has much meaning here, because those have converged. Looking at slide 53, to close the loop on this, in the Eco Oro case, another case by an investor against Colombia, the tribunal said Colombia correctly accepts that the tribunal is not rigidly bound by the standards set out in NEAR, and it is the tribunal's view that the standard today is broader than that defined in the NEAR case. And hopefully they will stand by that position in this case. Slide 54, please. So on slide 54 is a quote from the waste management decision, widely cited and widely followed in our field. And so what did they say? The minimum standard of treatment of fair and equitable treatment is infringed by conduct attributable to the state. here the CGR, and harmful to the claimant, which is certainly the case, not only being hauled into this proceeding and the subject of serious reputational harm, both from the filing of the case and then the false publicity surrounding it by the Controller General, but now being on the receiving end of an award for hundreds of millions of dollars. If the conduct is arbitrary, grossly unfair, unjust, or idiosyncratic, here it is, because it was a proceeding seeking billions of dollars when initiated and resulting in an award for hundreds of millions of dollars, based on the notion that a supplier of personnel having no authority over the expenditure of public funds could be held to account by the Controller General for allegedly having mismanaged a project that it didn't manage in the first place is discriminatory. And as I'll explain in a moment, the Colombian nationals, prominent citizens all, who make up the board of Ecopetrol, who were let out of the case, were similarly situated and had at a minimum the same defense that the claimants have, or involves a lack of due process, leading to an outcome which offends judicial propriety. And as Mr. Conrad was explaining, there was first an opening resolution, again, a document of enormous length, asserting charges. That was addressed in formal proceedings, the free versions, in which the claimants explained that they were not fiscal managers and could not be thought to be fiscal managers, and that the Jacobs report of Ecopetrol had concluded they were not fiscal managers. And nonetheless, unlike the Colombians who were let go for not having final authority, although as I'll show in a moment, they did have significant authority over the expenditure of public funds, the claimants were held in the case. And finally, in applying this standard, it is relevant that the treatment is in breach of representations made by the host state, which were reasonably relied on. And those are the representations made in the contract with Reficar, a public entity. And obviously, a limitation on liability for ordinary breach of contract, which is at most what was pleaded here by the CGR, limited to 10% of the amount of the revenues derived from the contract, is an extremely valuable incentive to an investor, knowing that liability is capped. And here, that cap, assuming liability could be proven at all, would amount to $25 million, which is a very small fraction of the 750 or 811, and the figures vary because of exchange rate fluctuations between the Colombian peso and the US dollar. But those are just grossly disproportionate. In the following slides, number 55 quotes from Glamis Gold, again addressing the question of the near standard and its evolution. I don't think there's any serious dispute that this is a well-pleaded claim of a violation of FET. At the merits, can Colombia, on a full record, attempt to explain and justify the conduct of the CGR? Of course they can. At this stage of the proceedings, based on their assertions that they did nothing wrong, in the face of these well-pleaded allegations, would it be appropriate to terminate this case before any hearing on the merits? It would not. Mr. President, this might be an appropriate time for a break.
Thank you. It's 2:30 p.m. So we have now a 30-minute break. We'll be back at 3 o'clock. Thank you.
And could I just, off record, could I ask the secretary to tell us what the time count is?
So, the floor is yours. So let's resume.
Thank you, Mr. President. So, continuing with our discussion of fair and equitable treatment, FET does include, contrary to what Colombia has stated, the legitimate expectations of the parties. We would refer to Waste Management 2, an extremely well-known and widely followed decision that explicitly includes legitimate expectations in the standard and explains precisely why they should be. Now, Colombia relies on Bolivia versus Chile for its argument that legitimate expectations do not form part of the standard, but that was a state-to-state dispute heard at the ICJ, and state-to-state disputes occupy a critical and important part of the public legal order, but they're entirely distinct from the relationships between investors of one state and another. For one thing, disputes between two states or between two sovereigns, and the disparities that lead to the treatment under treaty of investors are just entirely different. The case is simply an opposite. And if we could have slide 58, please. And Colombia goes on to argue that even if legitimate expectations are part of the FET standard, as indeed they are, claimants have not alleged sufficient facts to prove a breach of legitimate expectations. Once again, this is a mixed question of law and fact, inappropriate for decision at this stage of the case. But to the extent there were any burden on claimants at this point, they have set out an adequate claim of a breach of their legitimate expectations, both specific assurances given in the form of the contract with its limitation on liability and its other protective clauses, as well as the expectation that Colombia would administer its laws in a fair and even-handed and appropriate manner. For example, most importantly here, that the regime of fiscal control administered by the CGR would be administered only against fiscal managers and in a fair and reasonable and impartial way. And I should note here that the course of conduct here by the CGR from the opening resolution itself until the decision on the merits is an almost paradigmatic example both of the frustration of that reasonable expectation of due process, as well as a classic denial of justice. The opening resolution listed 30-some individual acts. The response that was filed in the free version, in addition to pointing out that the claimants were not fiscal managers at all, addressed those acts. Apparently, thinking better of the position they had taken, the charging document, what's referred to as the indictment by Colombia, went on a completely different footing and chose a completely different theory, pointing to the change controls, the change orders involved, and the, excuse me, and a joint and several theory of liability. Then, in order to meet the and I realize this of course couldn't have been pleaded in the RFA, but it will be adduced in this case, faced with the fact that the record was overwhelming that claimants were not fiscal managers. Colombia actually changed the law and then purported to apply that retroactively, including consultants on a vague aiding and abetting theory. And then when the final decision came out, it was yet again a complete change in legal theory and in its theory of damages, which meant that as a practical matter, claimants never had an opportunity to defend themselves. It was like the American carnival game of whack-a-mole. As soon as one of Colombia's claims had been refuted. Another one was floated in its place, and that is the basis upon which hundreds of millions of dollars are said to be owed to Colombia. Now, an arbitrary administrative act this is a separate point, or a subheading, I guess, of FET, can itself breach the fair and equitable treatment standard. Could we have slide 60, please? Now, as a general matter, it ought to be the case that arbitrary conduct by an administrative agency, as surely as arbitrary action by an executive agency or by a court, can trigger liability. And that is indeed the case in the Teco case. If we have, yes, thank you. The claimants argued that a tariff and administrative tariff review, administrative actions breached the fair and equitable treatment standard. And Guatemala argued in that case, as Colombia does here, that because administrative acts were subject to judicial review, it couldn't breach FET. And that was rejected there by the tribunal. And I mention again that it is our case that there is no effective remedy in the Colombian courts for administrative misconduct. And it is admitted here that there was no administrative remedy for the bringing of this case, the measure complained of in the RFA. And in Bagat versus Egypt, in a perhaps better drafted portion of that award, involving a criminal case, but for legal purposes, an important precedent. It's slide 62, please. The tribunal noted that denial of justice can include the entire criminal process, including the acts of the prosecution before trial, prosecutorial misconduct, or malicious prosecution, and as surely as bringing an unfounded criminal case can cause damage in advance of a criminal trial, even one in which the defendant is acquitted, let alone one here where administratively our clients have been condemned to pay enormous damages. That single step can trigger a liability. And finally, if we could have slide 63, as one element of the FET standard, claimants say that the claimants have not stated a claim for denial of justice. Colombia argues that denial requires the exhaustion of all local remedies and that exhaustion of administrative remedies is not enough. But the disagreement here, and what we heard this morning, it really comes down to the correct understanding of the term administrative adjudicatory proceeding. And Colombia argued this morning that that is a term of art in Spanish that refers to a particular kind of court in Colombia, one charged with the review of administrative action. Now, it's our position that the words mean what they say, that administrative adjudicatory proceeding refers to an administrative proceeding taking place in an adjudicatory manner, because administrative agencies do not always adjudicate. So in the United States, for example, the Securities and Exchange Commission both has proceedings before administrative law judges to determine whether or not an individual or a company has violated the anti-fraud provisions of U.S. securities law, and if so, to impose appropriate penalties, including monetary penalties or bars from the securities industry. But the SEC also has a rulemaking function, a non-adjudicatory function, in which they might, for example, amend or change or clarify the anti-fraud provisions. And that's the ordinary meaning of those words in English. There's nothing in the treaty, the notes to the treaty, that indicates that this was meant to indicate this particular kind of Colombian court. And the history of the treaty makes it clear that it was not. If we could have slide 64, please. This TPA had its origins with the model BIT, prepared and utilized by the U.S. State Department, and that's the 2012 model BIT. And when we look at the language of the BIT, which is up here on the screen, it precisely tracks the language at issue here. Administrative adjudicatory proceedings. That was obviously not drafted with Colombia in mind, because it's a model to be used by the United States as the basis for investment treaties, as it clearly was here. It was not drafted in Spanish. It was drafted only in English. And so it cannot be said to be referring to a particular type of proceeding in Colombia or countries that have similar legal systems to Colombia, assuming that this would be a term of art there. It means what it says. It means what it says in English, the language in which it was drafted. It means an administrative proceeding which is adjudicatory, as opposed to one which is rulemaking or legislative or another area in which administrative agencies act. And I'll note that in slide 65, in the Corona Materials case, the same claim that administrative adjudicatory proceeding had this special term of art meaning was rejected by the tribunal, following the rules of the Vienna Convention. It is correct that efforts should be made to harmonize treaties that are executed in two authentic languages. The only way in which to do that here is to give these terms their ordinary English meaning, because this is not a term of art in English. It is not a term of art in American law. And finally, I'll note that the construction urged by Colombia would leave a sovereign free to do whatever it wanted, free of the constraints of the treaty obligations it has before its administrative agencies, so that a $10 civil dispute before the Colombian courts would presumably could trigger liability under the treaty, whereas a $1 billion dispute before an administrative agency acting far beyond its bounds, according to Colombia, is subject to no constraints under the treaty at all. And again, as I said earlier, with respect to the availability of a judicial remedy in Colombia, that is hotly disputed here. It will have to be heard at the merits phase of the case. Mr. Torrente's witness statement in the interim measures case makes it clear that a nullity action would take, in the first instance, many years with levels of review beyond that. Colombia is free to contest that, but they are not free here to assert that that's wrong and that the case should be dismissed on that basis. Let me turn to the question of national treatment, which was also much discussed this morning. If we could have slide 71, please. Now, the pleading here alleges that the board of directors, the individuals who made up the board of directors of Ecopetrol, were treated more favorably under like circumstances than were the claimants, in violation of the guarantee of Article 10.3 of the treaty. Could we have slide 73, please? As we noted, although initially named in the opening resolution, the directors of Ecopetrol made a free version submission stating that they lacked ultimate authority over the expenditure of public funds and hence were not fiscal managers and hence were not proper respondents in the CGR proceeding. And that was granted by the CGR. And those individuals, all Colombian nationals, all prominent, were dismissed from the case. Whereas the same assertion, backed up by, among other things, the Jacobs report commissioned by Ecopetrol itself, were rejected by the CGR. They were in like circumstances. We're told in Colombia's papers and this morning that, well, other Colombians were charged, but that is irrelevant here because they were not in similar circumstances. We're told that precautionary measures were not sought against the claimants as if they had somehow been treated more favorably. But again, the test is whether or not in practice, and it can be de jure, it can be de facto, investors are entitled to the same treatment as domestic investors, and that was breached here. So the decision in SEDA, the submission of the US in SEDA takes that same position, that it may be de jure, it may be de facto. That's in slide 76. But here, I think it's very instructive to look at the submission made at the free version stage by the directors of Reficar. So could we put up slide 77, please? Okay, this is a chart that was submitted by counsel for the Ecopetrol directors in the free versions submitted to the CGR, in which the prospective respondents had an opportunity to explain why they should not be made actual respondents. And looking at this chart, it shows the flow of approval for the expenditure of funds on this project. And as you can see, it ends at the Reficar level in this orange box, aprobación, control de cambios. But the step before that, the sort of dark green diamond at the Ecopetrol level, that is the board of directors of Ecopetrol. They had the next to last step, and they could say yes or no. Whereas when you look at what Ecopetrol was representing, or the Ecopetrol directors were representing, there is no authority to say yes or no on the part of Foster Wheeler, the gray rectangle that appears at the top. It simply makes recommendations with no power over the expenditure of funds. And then it tracks through this decision tree, reaching the board of directors of Ecopetrol in the penultimate step, leading to approval by Reficar, which had assumed the management of its own project, as Mr. Conrad was describing this morning. This document was submitted by Ecopetrol, and it was included by the CGR in the charging document and adopted by them. If the directors of Ecopetrol, who had the actual authority to say sí or no under this chart, as to the expenditure of funds, were let out because they were not fiscal managers, because there was one more step in the process, then it cannot be explained how, on a chart adopted by the CGR itself, the claimants were held in. And the only plausible explanation for that is that they were not Colombian and the directors of Ecopetrol were. Now, there may be some answer to that, although I don't know what it is, but that is a question for the merits. This is a perfectly well-pleaded, plausible, and as this chart makes clear, true explanation of the denial of national treatment, which is a part of the FET standard that governs here. It cannot be resolved at this stage of the proceedings. And as this chart makes clear, in all likelihood, it will be resolved in favor of the claimants at the merits phase. Yeah. Let me turn to the question of most favored nation treatment under Article 10.4. If we could turn to slide 80, please. This is the MFN clause that appears in the TPA, and it's not atypical of such clauses in modern treaties. So Colombia raises a host of objections here. All of them rather complex and debatable issues of law. First, they say the MFN clause concerns only actual practice in comparison. How was a Swiss investor treated, in fact, in Colombia? That an MFN clause cannot import new substantive protections. But as I'll discuss in a moment, the TPA does include a limited umbrella clause with its reference to investment agreements. That umbrella clauses are contrary to public policy in Colombia, but Colombia has ratified at least two treaties that do have umbrella clauses, the Swiss treaty and the Japanese treaty, that the umbrella clauses in those treaties are not subject to mandatory arbitration. But the treaty here, the TPA, makes it clear that procedural provisions are not to be imported, and by necessary implication that substantive provisions are. And finally, they say that assuming that the umbrella clauses are imported, that Reficar is not a central, is not an agency of the Colombian government at the national level. As I'll show in a moment, it is, and we have stated a prima facie claim. So slide 82, please. This is the footnote in the treaty language itself that says, for greater certainty, treatment with respect to the establishment, acquisition, expansion, or so on, referring to the MFN clause, referred to in paragraphs 1 and 2, does not encompass dispute resolution mechanisms that are provided for in international investment treaties or trade agreements. Well, if the drafters excluded those procedural mechanisms, they necessarily, or it follows, that substantive provisions were included, as they generally are in this area of investment law. On slide 83, we quote from an article on this point, and we don't dispute that there is a dispute in the literature about the scope of MFN clauses and their incorporation of umbrella clauses. But again, this is a highly complex question of law, inappropriate for decision at this point. If it has to be decided, or were to be decided, the better view is that they are incorporated because of the overriding principle that investors of varying countries should be treated on an equal footing. On slide 84, along those lines, we quote from the award in Sirketi versus Turkmenistan, taking exactly that position. And on the following slide, slide 85, we quote from the decision in Bayandir versus Pakistan, holding exactly that a more favorable substantive standard of treatment is incorporated. And I'll just stop to note briefly that the suggestion made this morning as to the lack of mandatory arbitration in the Swiss treaty somehow suggests that Colombia is free to ignore the substantive provisions of the umbrella clause there. I'm fairly sure that's not what they meant to say. Again, on 86, we cite from the EDF decision, EDF versus Argentina, where under the Argentina-France BIT, the umbrella clause was imported. And we cite further decisions there. And then on slide 88, we cite the language we rely on from the Colombia-Japan Treaty and the Colombia-Switzerland Treaty. As Siemens holds, looking at slide 89, the intended result of an MFN clause is to harmonize benefits agreed with a party with those considered more favorable granted to another party. The Swiss treaty grants rights under an umbrella clause to Swiss investors. The Japanese treaty grants rights under an umbrella clause to Japanese investors. The US investors here should be granted those same rights. And Siemens goes on to hold that the disadvantages of that treaty, here presumably the lack of mandatory arbitration, don't travel with the substantive right. And there's no reason that they should, because those rights are presumably going to be honored by Colombia. So what is imported here? An umbrella clause imports a contractual undertaking. Now, the undertaking here is expressed in the Reficar FPJVC contract. Bear with me one second, Mr. President. Well, I'll address the question of Reficar as a national authority in the next section of our discussion concerning investment claims. Investment agreements. Let me turn to that. Article 10.28, which is cited on slide 93, defines an investment agreement. And so the only point of dispute here, since this was a contract for a multi-year investment in Colombia on a major project that took years, involving the expenditure of billions of dollars, is whether or not whether or not the investment consisted solely of the contract. And Colombia keeps saying that. But that is not the claimant's position, and it is not the position pleaded in the RFA. As Mr. Conrad was explaining, and as cannot be challenged really at this stage of the proceedings, the investment was time, capital, personnel, facilities, labor invested in Colombia for years, in keeping with the definition of investment in the TPA itself, and there is no other definition of investment in the ICSID convention. So Colombia argues next that Reficar is not a national authority of Colombia. Again, a fact-specific question and a mixed question of fact and law. But Colombia, acting through its Ministry of Finance, the owner of Ecopetrol, and in sequence, Ecopetrol's wholly owned subsidiary Reficar, gave the right to enter into contracts with the government. And Ecopetrol and Reficar have the function of concluding contracts for the exploration, exploitation, refinement, transportation, distribution, and commercialization of hydrocarbons by the National Hydrocarbons Agency, as explained in our counter memorial at paragraphs 108. And in Colombia, all hydrocarbons are the property of the state. Now, the claim was made before that Reficar is not at the national level, the central level of authority. Could we put up the slide from their presentation, please? But in fact, this is the slide that was referred to, where Reficar is referred to as a decentralized entity. Decentralized entity is a term of art in Colombian law. It does not mean an entity not at the central level of government. And in fact, when you read along in this slide that they relied on, it is a decentralized entity at the national level. The Ministry of Finance is decentralized, can refer, as I understand it, for example, to an entity not in the capital. It can refer to an entity not literally in the center, but it does not mean not at the national level, not at the central level of government, because there the distinction would be between a public entity owned, say, by a departamento or by a municipality. And there were plenty of those. So that an electric company owned by the city of Bogota, the municipality of Bogota, would not be at the central level of government. But as the pleading they rely on makes clear, this is a term of art, decentralized entity at the national level. It's Colombia's pleading.
Mr. Seals, you made a reference to this slide. There was the slide
This was a slide.
I was mentioning, yeah, but for record purposes, I think it would be important to make reference to slide number. I cannot read from here, 112.
Your eyes are better than mine, Mr. Chairman.
Yeah, 112 from Colombia's Today presentation.
Yes.
Okay, just for our reference, because we, in 1 week, we may have forgotten this. Thank you, and my apologies for interrupting.
And no, I'm glad to have the chance to clarify. And obviously, the chain of ownership here is the Ministry of Finance, which is clearly at the central level of government, which owns and has delegated to Reficar critical functions here, which in turn owns and organized Reficar for the purpose of carrying out this project. So it is only at the central level of government that these entities exist, and hence this is a contract with an entity at the central level of government. And I'll also note that in the ICC proceeding that Reficar has commenced for unspecified contract damages against FPJVC and its members. So Reficar took the position that before, is this an submission? Reficar simply took the position that even for something that would be ordinary in commercial case as approving the selection, the designation of an arbitrator to the tribunal, it needed to secure approval as a public authority from the office of the President of the Republic. It conducts itself as a public authority. It is a public authority. The contract between Reficar and FPJVC is a contract with an arm of the Colombian state at the central governmental level. The next claim that's made is one of indirect expropriation. And Colombia argues that it's not possible to expropriate specific contract provisions. But the charges as made, and certainly the award which has now been rendered, have destroyed the value of the investment, the very meaning of indirect expropriation. And what has happened here, Colombia entered into a commercial arrangement. Colombia entered into a commercial arrangement under which it was to ended up paying roughly $250 million for under the contract. Having received the benefits of that contract, and the refinery is up and running, Colombia decided to put on its sovereign hat, if you will, and exercising its government powers in an entirely arbitrary and unreasonable way, sought to extract and is in the process of attempting to extract hundreds of millions of dollars, three times at least all the revenues paid under the contract and received by my clients. And if my math is correct, more than 100 times the profit. That is an expropriation, to take the benefit, to cause the investment to be made, and then to attempt to deprive my clients of the benefit of that investment by the arbitrary exercise of governmental power. The next question raised by Colombia concerns damages. Could we have slide 103, please? Good. So Colombia has a host of objections on this. First, that they say claimants had not incurred any damages at the time of the RFA. But as you can see on slide 105, thank you, claimants did allege damage in the RFA. They alleged from the making of the charge, reputational harm, which is compensable, and the expenditure of attorney's fees in defending that baseless charge. Now, Colombia cites to Chevron as saying attorney's fees are unrecoverable. But what the award in Chevron that they quote from actually says is that there had been no proof of the amount of the attorney's fees. And those were fees incurred as a result of delay. The claim here is that we never should have been respondents at all, and attorney's fees are the natural and probable consequence of the claimants having to defend themselves, separate and apart from the reputational harm. Now, there's also a claim that moral damages are not permitted. Slide 106, please. Now, moral damages, of course, that's simply a term of art for reputational harm. And they are pecuniary damages. They are compensable in money. They're compensable in money for the loss of business that results. This is not a claim for hurt feelings. It is not a claim for punitive damages. It's not a claim that Colombia should somehow be punished for its unconscionable conduct in waging a campaign in the press when it was supposedly a neutral decision maker. Those may all be reprehensible, but that's not what we are seeking here. The claim for reputational harm is one that resulted in the loss of business. And that is a pecuniary loss that can be compensated for here. Looking at slide 106, as Professor McLaughlin says, there is no controversy as to whether moral damages can be obtained under classical principles of public international law. The next slide cites from Desert Line versus Yemen that moral damages are recoverable. The International Law Commission cited at it's slide 108. The injury for which a responsible state is obliged to make full reparation embraces any damage, whether material or moral, caused by the intentionally wrongful act of a state. Material and moral damage resulting from an intentionally wrongful act will normally be financially accessible and hence covered by the remedy of compensation. And yes, if it is I'm sorry, I misread it. Resulting from an internationally wrongful act. Yes, thank you. As this one was, as we have shown. And to close on this section, on slide 109 is a quote from Colombia's recent submission in SEDA. And what do they say? In sum, while it is undisputed that the tribunal has discretion to determine whether the claimants are entitled to moral damages and in what amount, the respondent respectfully submit that the claimants have not shown that the exceptional circumstances to award, and it goes on to say moral damages are present here. Well, they're telling here, Colombia, not Colombia's lawyers, but Colombia has taken the position that moral damages cannot be recovered in investment arbitration under any circumstances. We heard that this morning. But in the SEDA case, they said, well, they're available but hard to get. If they're available but hard to get, that can only be determined at the merits phase. It is not a basis for striking the pleaded request at this preliminary stage of the proceedings. Because there has to be a showing. There's no showing here because this is not a trial or a mini trial. No witnesses are being called. So Colombia also argues that there cannot be an offsetting award here. But that's a remedial question for the end of the case, not a preliminary question for the beginning of the case. Of course, in Glencore, an offsetting award was granted against Colombia for the misconduct of the CGR in assessing damages against Glencore on what the tribunal concluded was an irrational and unsupportable theory. Now, Colombia distinguishes that by saying, well, they paid the money and then they sued to get it back. That's true, but it's a distinction without a difference because that has to do with the form of the award. And now in the RFA, we stated that the outcome of the case was predetermined, that there would be a substantial award. Indeed, that has come to pass. As the case progresses, the events since the RFA will be brought into the case. But could the tribunal craft an award that compensated, an offsetting award that compensated the claimants for the wrong done to them and avoiding the kind of windfall we heard about this morning? Of course it could. An award could be entered and stayed, subject to the stay being vacated only if Colombia, as it apparently intends to do, finds and seizes assets and sells them or converts financial assets to its own use. If they don't do that, then no harm to them. If they do that, it would be fine. Would that have to be crafted, or could that be crafted as a partial final award so that the tribunal would have the continuing power to police it? Yes. At some point, Colombia will run up against its own statute of limitations, and the award will no longer be collectible. I believe, although subject to correction, that period is 5 years. But these are premature questions. I mean, the scope of the relief to be granted, the precise form of the decree, will depend upon all the facts shown at the hearing on the merits. Is this a form of relief that cannot be granted? I don't think so. Is it a form of relief that would be crafted excuse me, to avoid an imbalance between the parties? It would, it could, and I'm confident, we are confident, that the tribunal could readily do that. But dismissing the claim at this point, when the claims will be amended, the facts will be supplemented, we will show, as the case progresses, that an offsetting award, as in Glencore, is an appropriate remedy. But the notion that the case should be dismissed with finality at this point in time because the scope of relief has not been precisely determined is just wrong. And in any event, there is a present live claim for damages for the reputational harm suffered from the bringing of the claim. I don't think it's a leap of imagination to appreciate that for a company engaged in the construction of projects like this throughout South America and elsewhere in the world, that the bringing of this charge and its publicity and the publication of these defamatory statements by the CGR had the capacity to and did materially harm the company's business and its ability to garner similar projects elsewhere. Let me turn to the question raised of a qualifying investment. Investment is broadly defined under the TPA. Could we have slide 115, please? And it includes turnkey construction, management, production, and similar contracts. It's interesting that Colombia now seeks to minimize the contract when the whole basis of the CGR proceeding was that the claimants somehow managed and mismanaged this project. The two cannot both be true. But there is no definition of investment in the ICSID Convention. There is a broad definition in the treaty itself. As Mr. Conrad explained, significant assets were committed on the ground in Colombia over a period of many years involving a contract not worth billions, but worth to the claimants hundreds of millions of dollars in revenues. That is the classic definition of an investment. With regard to the claims regarding risk that were made, there is risk, there was risk, as Mr. Conrad explained. In any event, as some tribunals have held, we could have slide 120, and appropriately held, the existence of a dispute like this shows there was risk. There was risk not only of non-payment, there was risk of penalties. And the mere fact of investing in a country, committing resources, as happened here, is itself evidence of investment and investment risk. Slide a minute. Let me have slide 121, please. So here's a quote from the Cellini Award. A construction that stretches out for many years, for which the total cost cannot be established with certainty, creates an obvious risk for the contractor. In the AMF case, cited at slide 122, the long duration of the operation meant that a great number of events and contingencies could have happened to the asset while being utilized in another country, including governmental actions, which is, of course, what brings us here today. Due to the location of the asset and the duration of the operation, claimant's risk was not limited to non-payment or general business risk. And that is exactly the situation here. And whether or not this was an investment under the broad definition in the treaty, whether or not there was risk is, again, a mixed question of law and fact that cannot be decided at this stage of the case. It should be heard and decided on a full record. Do we have the burden of proving that there was an investment? Of course we do, because that's an element of our claim under the treaty. Do we have the burden to prove it at this point? With witnesses, with documents, on a full record after disclosure? We do not. Colombia has jumped the gun on this, as it has on virtually every other question that it raises. This is not the appropriate procedural setting to resolve these questions. When they are resolved, they will be resolved, we are confident, in our favor, because the facts will support us. But this is not a factual contest. This is not a hearing on the facts. Let me turn, because time is running short, Mr. Chairman, to the question of the waiver, about which we heard so much this morning. And on slide 124 is the language of the treaty calling for a waiver. And on slide 125 is the language of the RFA, which tracks exactly the language of the treaty. What is called a reservation just says, for the avoidance of doubt, that the waiver is without prejudice of claimant's right to defend themselves in the fiscal liability proceeding. Colombia actually has gone so far in its papers, and as they clarified in their argument this morning, to suggest that in order to meet the condition of the waiver, the claimants were obligated to stop defending themselves in the CGR proceeding brought by Colombia, and seeking at that point to recover more than $2 billion from the claimants. It cannot be that simply defending oneself against a legal assault by the state violates the waiver. No case has ever suggested that. No award is cited for this extraordinary proposition. This is simply noting a right that claimants had and still have. That is the right to defend themselves. It is not a reservation. It's not a condition. It's not an exclusion, and hence is readily distinguishable from the cases that Colombia cites and relies on. If we look at slide 126, the RDC case that they cite, there was language going beyond the exact words of the CAFTA Treaty, which is substantially identical here. But nonetheless, that was held to be an effective waiver. And if claimants have the right, as they do, to defend themselves, then noting that they maintain that right can't violate the waiver. Clients can only be required to waive the rights that the TPA requires, and that is to initiate or continue. And the only fair way to read that is to initiate or to initiate and continue. It is meant to, as Colombia points out, it's meant to prevent the bringing of a second proceeding, a second bite at the apple, the possibility of a contradictory result. Defending oneself against Colombia cannot possibly do that. Now, the Renko case, on which Colombia relies so heavily, was entirely different. That was a true reservation of the right to initiate proceedings following the waiver. That is not this case. There's no reservation of the right to bring a proceeding by the claimants here. So what does Colombia point to? Colombia points to the various tutelas. There were two tutelas brought after the RFA was filed. As Mr. Conrad explained, neither of them implicates the waiver because both were on narrow technical points having to do with the proceeding, the CGR proceeding itself. The first was seeking the right to cross-examine an expert witness. The second sought more time to respond to a filing of thousands of pages by the CGR. Both were denied. Neither of them implicated the waiver because neither of them sought to challenge the measures complained of. Now, and the Thunderbird case, which is cited at slide 131, makes it clear I'm sorry, let me back up if I could. Could we have slide 128? In the RFA, it is the bringing of the fiscal liability proceeding that is the measure complained of. Neither of these two teles challenged or otherwise implicated that. And claimants respondents also point to what they call the appeal, but that was all part of the CGR proceeding. The CGR issued, in effect, a tentative decision by the deputy controller. Comments were allowed to be made on that. Comments were filed by the claimants. They were rejected, but that was simply part of the ongoing defense of the CGR proceeding. All part of the same proceeding, all before the same body, all part of responding to Colombia's legal assault. It was not a separate proceeding. It was not a proceeding initiated by the claimants. It was not a proceeding continued by the claimants, except in the extraordinary sense in which Colombia insists that the claimants were obligated to stop defending themselves before the CGR in the CGR proceeding that the CGR had initiated. Could we have slide 132, please? Now here, Colombia addressed the purpose of the no U-turn provision. And the clear purpose, they say, of the condition is to prevent the same claim from being heard simultaneously by several local and international tribunals. But the claim is not being heard simultaneously there. And so they turn to the conciliation request filed by the claimants, which was recently admitted into the record. The conciliation request doesn't violate the waiver because it is not a proceeding. It is not an other dispute settlement procedure. It is exactly what its name suggests. It is a voluntary effort to resolve a case. It is a mediation being conducted under state auspices. The mediator, the conciliator, has no coercive power. No decision can be made other than by consent of the parties. And the notion that an effort to resolve a case by consent voluntarily, although the CGR has rebuffed all those efforts, it somehow violates the waiver provision, makes absolutely no sense. Colombian policy and international policy favor the voluntary resolution of disputes. It's as if I were to write a letter to Ms. Frutos Peterson suggesting that we have lunch and discuss a possible resolution of the case, and then we would hear that we had violated the waiver provision, because that would be a settlement discussion, which would be a procedure in violation of the waiver provision. It simply cannot be. And as for the claim that a nullity action will follow, that is simply unfounded. What the conciliation request actually says is not that an application to nullify will follow. It says it could follow. It's an available remedy. There's certainly no assurance that the claimants will file such an action. And the notion that a prediction about what claimants might do somehow triggers the waiver, a violation of the waiver clause is just unfounded. There is no nullity action. There may never be a nullity action. If such an action were to be filed, Colombia would be free to make its arguments, but there is none. There may well be none. What there is now is an effort to conciliate the case, a good faith effort to resolve this dispute by consent, which is an outcome that would be favored by Colombian policy and by the policy of the treaty and by international policy in general. And Colombia's attempt to construct a violation of the waiver clause out of that act of good faith, I think shows the extent to which they will go in attempting to rid themselves of this case. It is entirely unfounded and cannot possibly be the basis for seeking dismissal. We go to slide 139, please. There was a lot of discussion this morning about FPJVC as a national of another state. It is a contractual joint venture. It is organized under New York law. It is undisputed here that under New York law, a joint venture can sue and be sued in its own name. It can own and possess property, both real and personal. It can employ individuals. What they have done is they have conflated the fact that under New York law, a joint venture is not an organization with limited liability, with the notion that it is not an entity at all. And I should note, by the way, the case that was cited to the tribunal as coming from the New York Court of Appeals, which is the court of last resort in New York, was misdescribed. That is actually a decision of the appellate division, which is the intermediate appellate court in New York for the 4th Judicial Department, which sits in Rochester, New York, and from which an appeal can be taken to the Court of Appeals by permission. It is not a decision of a court of last resort. But again, this is a question of New York law. It is much debated here. The treaty itself describes a joint venture as an enterprise, and an enterprise in turn can be an investor. The ICSID Convention does not define a juridical person. And rather strikingly, it was with FPJVC that Reficar, a public company of Colombia, contracted. So they seem to be suggesting now that they contracted with a non-existent entity. FPJVC is a juridical person. There is no basis for FPJVC to be dismissed from the case. It appears to be Colombia's hope that they could prevail on this issue and then make their argument turn around and say, well, but FPJVC is only its members, but because the notice of intent was made in the name of FPJVC, question I'll turn to in just a moment, that too is a nullity, and they both cannot be true. And the cases are cited in our papers, the New York cases. They are described at slide 145, and we can skip slide 146, which shows the signature on the contract of FPJVC, not the two claimants. At an absolute minimum, that claim, like all of Colombia's other claims, is premature at this point, and it is in fact simply wrong as a matter of New York law. There was a fair amount of talk this morning and in the papers and as was pointed out before, indeed in opposing registration of this claim, that the notice given was somehow ineffective. The notice which appears at slide 149 clearly describes the dispute, clearly describes FPJVC as being a contractual joint venture of its two members. This cannot have been a mystery to Colombia because Colombia named the two members of the joint venture as respondents in the CGR case. And the only fair construction of the notice is that it refers to FPJVC, but correctly identifies all three of the claimants. And in fact, the point of the notice is to afford an opportunity for conciliation. As I described a little while ago, Colombia never responded. And the notion that Colombia would have responded if there had been a change in the parties identified in the ray line of that letter, I have to say is fanciful. In any event, as the case is cited in our papers and described in slides 152, in slide 152, make clear minor discrepancies or deficiencies in a notice of intent cannot destroy jurisdiction. There is, as everyone on the tribunal knows, a view that notices of intent are themselves precatory, and that the failure to comply with them, at least in technical ways, is not jurisdictional. Colombia got adequate notice. They were not prejudiced. Their insistence upon strict procedural formality, assuming that it was violated at all, has no place in a case like this. Let me return in the time I have remaining to the fork in the road question addressed by Colombia this morning. Could we have slide 135, please? The fork in the road claim that Colombia makes concerns the first tutela, which was made before the RFA was filed, and hence obviously cannot implicate the waiver clause. And as explained in our papers, that tutela was expressly limited to claims under Colombian law. It is true that it refers to rights under the treaty, but reserves those rights for this proceeding. No relief was sought under the treaty in Colombian law, in the Colombian court, assuming that the Colombian court even had jurisdiction to consider that. And again, the objection made here is not substantive, but technical, or I think more properly, hyper-technical. The claim is that because there is a non-operative reference to the rights under the treaty in the context of a claim which by its terms is limited to Colombian law. And we heard a lot about the word allege. So the mere mention somehow transforms that into a violation of the fork in the road claim. Requirement cannot be sustained. The fork in the road provision is meant to prevent submitting the claims that are before the tribunal to a national court. This was the exact opposite. These were claims under Colombian law submitted to a Colombian court. And the fact that the pleading there makes a reference to the existence of international rights does not transform it into a violation of the fork in the road provision, because it disclaims seeking relief under such rights. The rights that were invoked were Colombian rights. There is a reservation of rights in that pleading as to international rights, and the effort to turn something that is in the pleading at most for informational purposes into a waiver should be rejected. All right. So where we are is that Colombia has, having received the benefits of the claimant's work, having received the benefits of the contract it entered into, then turned on the claimants and, marshaling all the powers of the state, began a proceeding against the claimants, seeking many times in damages the amount of revenue derived by the claimants from doing their work in accordance with the contract, as I say, which was performed without objection by Reficar. And that proceeding was marked by gross irregularities. It is an outrage to due process. It is an outrage to international law. It was a shifting series of claims, all without any factual assertions that would link the claimants in any way to fiscal management, on a shifting series of theories, and assessing liability on a joint and several basis without even an attempt to ascribe any wrongful act to any claimed item of damage, for which my client's entire business is now at risk. And the fact that Colombia has so far not succeeded in its efforts to seize and sell the assets of the claimants is very cold comfort indeed to my clients. This is a well-pleaded, sustainable, well-supported claim of wrongdoing under the treaty in violation of the terms that Colombia entered into to protect investors from the United States. And the claim should be allowed to proceed to the merits phase, where it can be heard on a full factual record as the parties contemplated, as the treaty requires. Thank you, Mr. President.
Thank you, Mr. Sills. It's 4:20. We had provided for a slot here of 1 hour. I'm sorry, for 30 minutes for the U.S. to submit oral sort of arguments. But it was confirmed to us yesterday that the U.S. will not submit such arguments. So the next activity we have is the questions from the tribunal. And I would like to consult with you if you would be willing to have a 15-20 minute break so that you can relax a bit, especially claimant has just finished making a long presentation. And we come back at 4:40. Is that okay?
Mr. President, I'm always in favor of relaxation.
I will not oppose to that, Mr. President. But just one minor point, but important point. We were happy to see that council finished with their presentation, but there was in excess of time. I just would like to have the same rule applied in case that we go over a little bit on our closing, because there was a lot said.
I was relying on Marissa's computation of time, and I think they did not exceed, did they?
2 minutes. Yes. Yeah,
2
yeah.
minutes.
On our account, yeah, because our counting is different. But anyway, if it is 2 minutes, 2 minutes.
Still
Thank you.
got it. Even 5. Okay, thank you. We'll be here at 4:40.
Thank you.
Okay, now you have this slot for questions by the tribunal. And we'll start with Mr. Beachy, who will address the questions to the parties.
Thank you, Mr. President. Just a couple of things from me, if I may. And the first is perhaps a bit of a sidebar, but it may be relevant to us. At paragraphs 72 to 74 of the request for arbitration, there's reference to the ICC arbitration brought by Reficar against CB&I for damages for over 2.4 billion. We were told that that was an arbitration from which FPJVC had been excluded as a respondent. And we're also told, tantalizingly, that the hearing on the merits is presently scheduled to take place in April 2020. If that's a matter within the knowledge of the parties, might we be told how that matter now stands?
Mr. Beachy, this is Charles Conrad on behalf of the claimants. I can address that question to the best of my abilities, just because you're correct. Claimants are not part of that proceeding. It's our understanding is that hearing has concluded and is waiting a final award.
Nice to know that my old shop still moves with a degree of celerity. So as yet no award, essentially. All right. The second point is this. Picking up on the discussion this morning, it was put to us that we should be considering the claims as the position stood at the 8th of December 2009. 2009, yeah, 2009, yeah. 19, I'm sorry. I'm wishing away 10 years of my life. Taking that as my starting point and looking at the request for arbitration, I quite see the argument that matters that occur some years down the track, or matters which are simply the subject of speculative inquiry, as at that time, might properly be said to be the subject of some objection. But where, Mr. President, I have some difficulty is if you look at the request for arbitration, there's a number of matters there which are clearly said to be crystallized. In other words, there are wrongs which are said already to be apparent as at that time. It's true to say that the relief sought goes, among other things, but principally to reputational damage and the like. And it's also true to say that matters are not quantified. But is it right to say that on the basis of the request, the claimants have not already put forward, as at December 2019, matters which are now in front of us and which then we might properly be in a position to debate, because they're not matters which have occurred. We're not being asked now to consider matters which have arisen later beyond the ambit of the request for arbitration. I'm sorry, it's a 50-page request for arbitration. I'm not expecting you to read it straight away now, but it did seem to me that you were taking a very narrow view of what had actually crystallized as at that time. And I'm just inquiring of you whether, given what is the content of that document and the way in which the arguments have been developed, are you saying to us that we shouldn't have regard to any of the substantive wrongs which are said to already have occurred at that point?
I will answer your question, Mr. Beachy, but of course, tomorrow we will elaborate more on this point precisely in our closing statements. What I can tell you, I don't have the request for arbitration in front of me, but I do recall the relief that they were asking for. And if I'm correct, they include reputational, yes. What I want to say at this point, Mr. Beachy, is that the problem that we have here is that, well, not our problem. I think we submit that it's claimant's problem, is the language of Article 1024. And because that article, of course, will take you back to Article 1016.1. And if you read 1016.1, you need to establish the breach, and you need to establish harm that arises from that breach. And that's why when you go back to Article 1024, it gives you the standard to assess that breach under Article 1016.1. And that standard is in Article 20. I'm sorry, this is something not in my memory. And that is, of course, 2010 4, paragraph C, where it gives you the standard to assess, the facts as of the time of the notice of arbitration.
Well, I agree. But I mean, there's a difference, isn't there, between saying that as at December 2019, there is a positive case being put forward on a particular ground or particular grounds which give rise to particular relief. And you're right to say that at that time, there was a request for an order for damages for economic and reputational harm suffered, including an offsetting award and costs and attorney's fees, but also there's a declaration that there has been a breach of obligations under the TPA. And I think my point to you is that the request for arbitration is not a bare document. It does actually set out what are said to be breaches of obligations which have already occurred as at that time. And then we get into an issue about the merits, which is why I don't want to get into a debate with you, because that, if it were right, would be the subject necessarily of a later date, but an argument at a later date. But on the face of it, I'm just pushing back on this suggestion that if you take a very narrow view, or are you entitled, in fact, to take such a narrow view of what is said to be the position as at December 2019?
Mm-hmm. And I think we are, because as we explained in our submissions and during the hearing, at that time, that moment of the notice of arbitration, the only
request for arbitration.
Request for arbitration or notice of arbitration, I think is called under the treaty, but the request for arbitration. What you had is an indictment order, and it is Colombia's submission, and we submit to you that we have proven that under Colombian law, an indictment order is a mere administrative act by the authority. So if you were to agree with us that it's a mere administrative act, then there is nothing there, because, so you will, the fiscal liability proceedings hasn't even started at that point. Mm-hmm. Not even the ruling, of course, as a natural consequences. So if you take that particular date, as we show you in our timeline, nothing had happened yet. So the requirements made by the treaty are important to respect, because, of course, that's the intention of the contracting states. And if you don't have that breach that arises out of the harm at that time, you actually do not have the consent by the contracting state, to submit the dispute to arbitration. So that is why we explain in our submissions and during this hearing, the importance and the of the date, but also for you to understand what is the act that you had at that time. And at that time, the only thing is the indictment order, or what the claimants call the CGR charges.
Yeah. All right. Thank you.
You're welcome.
Do you want to comment on that?
I would, Mr. Vici. Thank you. We are where we are because Colombia elected to move on preliminary objections. In effect, they froze the case in time. If the case had proceeded in the ordinary course, we would have amended with all these subsequent events and hope to do so eventually. But I think the question makes it clear that at the time the RFA was filed, there was, and it pleads, a crystallized actionable wrong. Now, I don't want to address the merits of this claim about it being an unreviewable administrative act, but as we explained in the course of today's proceedings, and as we explained throughout, this charging document didn't come from nowhere. There was the opening resolution, in effect, the proposed charges, albeit on a completely different theory, to which our clients submitted, in effect, their opposition. That is, that they were not fiscal managers and hence could not be brought into this proceeding. The same submission was made by the Ecopetrol directors. The charging document, what Colombia calls the indictment, followed there. So there were proceedings before that leading up to the charging document. And the charging document, it is an act of the state. And the fact that as a matter of Colombian law, it's referred to as an administrative act, I have to say with respect, is meaningless for international law purposes. It's an act of the Colombian state through its instrumentality, the CGR. And it caused real, as I think the word is exactly right, crystallized damages, as we plead here. And particularly coupled with the campaign of publicity being improperly waged by the CGR around that charging document, caused reputational harm. And the RFA goes in some detail into that. The fact that it hadn't been quantified is at the point of the RFA is something one would expect in any case, because quantum is dealt with later. But there was real harm traceable to a decision that Colombia has told us there was no recourse on, there was no administrative remedy, they say, for the filing of what they call a mere administrative act. There was that first tutela that sought relief under Colombian law, leaving our clients with essentially no choice. So as at December 8, 2019, there was real harm, and as pleaded, arising from a violation of Colombia's treaty obligations to investors of the United States. Now, as the CGR matter has progressed, have other wrongs occurred and have further and more substantial damages been incurred? The answer is yes. And at some point, those will be put before the tribunal, and but for the stay of proceedings that resulted from the making of this application would already be before the tribunal. But I think your question highlights the fact that the measure complained of, the issuance of what they call the indictment, in an end of publicity caused real actionable harm. And that's before the tribunal. It's for the tribunal to resolve on the merits, but the notion that no harm was pleaded is just wrong and is belied by the record.
Mr. Vicci, I just want to add to this exchange because I think they are starting with the wrong premises. When we talk about that indictment order, we describe it as an administrative procedure in the whole process, and it's not a decision. It doesn't have that nature of to be obligatory, because it is the initial step that will actually push, the process to start. So the fact is, as we demonstrated in our submissions, is not even something that you could appeal. So after the indictment order, the process about an evidentiary stage starts. And then you have the following one, which is the proceeding, the proceeding, and then the ruling. When you have a ruling, then you have a right to appeal that ruling. You saw our big diagram. You know that now because we also have explained that process in the hearing during provisional measures. But at this stage, as we show you in our timeline, we continue to be at the administrative level. So that is why there is a misunderstanding in the conception that the claimants are putting the case forward, because what we have here is not a judicial decision by the state. There is no final act. So you need to wait to that to have, a measure, a breach that arises, a harm arises out of that breach. So as we pled in our case, you have to give the opportunity to the state to correct itself if they can do that vis-a-vis that, or they will correct themselves or not. They might decide what the CGR did, it was not proper, and then they annulled the whole process. So this is the situation that we have.
All right, I think we better leave it there before we do start walking down the line towards the merits.
Mrs. Peterson, I'll ask you to help me to understand. I think I got a bit lost. And so if you could walk me through the administrative procedure in Colombia, or correct my understanding. Let's take the indictment. And you use this expression, but perhaps it may mean that it's admissibility of the administrative procedure against the parties. Is that the spirit? Is that admissibility process or not?
I think it's the spirit, but I will let my colleague from Colombia to answer that directly.
Okay.
Because I think she's a Colombian lawyer and she will clarify that for you.
Thank you, Mr. President. Can you hear me? Yes.
Yeah, sure.
All right. So just stepping back a little bit to describe what happened. The fiscal liability proceeding is a proceeding of an administrative nature. It means it happens before an administrative authority, which is the CGR, right? So it starts with an initiation order. And that simply means that the CGR is going to look into a situation that perhaps may have caused the damage to the state. There's a preliminary investigation that happens. Then the next big step or milestone in the process is the indictment order, or as the claimants called it, the CGR charges. That's still an administrative act of procedural character. What does it mean that it has procedural character? It means that it gives impetus to the process, but because it doesn't define a legal situation of the parties involved, it's just, a next step in the process. it's an administrative act that doesn't admit any recourse. It's nothing has really happened. It's just the moment where the CGR decides that there's enough to proceed to an evidentiary period to gather more information to ultimately decide in a ruling whether there is or not fiscal liability. So those three are the main milestones of the process: the initiation, the indictment, and then the ruling. When claimants initiated this claim, we were after the indictment order during the evidentiary period. So the only real act at that point was the indictment order, which, as we've explained, is a mere procedural act. It's not defining any legal situation. It's in Spanish is un acto de procedimiento. Es un acto, es un
mero trámite.
A procedural act or a merely procedural act.
That's the Spanish terminology. Versus un acto administrativo definitivo, which would be the ruling. And then just to finalize, the ruling can then, because it's a definite administrative act, can then be annulled in the courts. It's only the ruling can go to the courts.
Yeah, let me ask you something else. Which is the word you use in Spanish for indictment?
Es el auto de imputación.
Okay.
Mm-hmm. That's why I said it's kind of like the administrative.
You know,
okay. As they say, charging.
It's charging. Charging, yeah.
Charging them.
Mm-hmm.
Okay.
That's why I said to your question originally, yes, it's kind of like the admissibility kind of thing that, yes, let's look into that.
Yeah, it's a mix of everything.
Yes.
So I think your question is pertinent. Let me use the words in Spanish. Is auto de apertura is what we call the opening order or initiation order.
Mm-hmm.
Auto de imputación would be what we call the indictment order. They call the CGR charges.
Yeah.
And then fallo con responsabilidad fiscal is what we call the ruling with fiscal liability, and they call the CGR decision. Those are the three main.
Yeah, we are neighbors, so there is not much difference between your system and ours in Brazil. Okay.
Mr. President, could we comment on that?
Yeah, absolutely.
Thank you. So the description we've just heard of Colombian administrative process, assuming it's accurate, is not the relevant inquiry here. For one thing, there was a decision, as was just described. There was the opening resolution, there was the submission of the free versions, and there was a decision. The decision was that the Ecopetrol directors, who were named in the opening resolution, were dismissed from the proceeding based on their claim that they were not fiscal managers. My clients were not, although they had at least an equally strong claim for that and made that same submission. So there was a decision. The fact that Colombian law characterizes this as a non-final administrative decision doesn't mean it wasn't an act of the Colombian state that caused real harm and real damage to our clients. And that's the essence here. The fact that there was, as we were just told, no recourse only highlights the fact that it was an act causing damage that could not be remediated. And the discussion about waiting for the ultimate award and then pursuing this remedy, which we say is illusory, in the Colombian courts because it would take so very long, as Mr. Torrente explained, really has to do only with the denial of justice claim, because that's where that kind of exhaustion requirement applies. But this here, it's the issuance of this groundless claim and then the publicity around it by a supposedly neutral decision maker that caused the real damage. And that's not damage that could have been remediated by going on for years and seeking what we were just told was the possible favorable decision of the CGR, which of course never happened, or then spending years in the Colombian courts pursuing an illusory remedy. The harm, as Mr. Beachy's first question to the respondent, I think, brought out, was that there was a real, definite, crystallized act at that time, and a well-pleaded, and I don't mean to suggest that Mr. Beachy said it was well-pleaded, but a pleaded claim, and I would say a well-pleaded claim, of damage from that act of the state at that time in violation of its treaty obligations. Now, they can dispute that on the merits, but that is not an appropriate preliminary objection. And it's not an appropriate objection to raise in any context at this stage of these proceedings.
Thank you. Okay. 5 minutes.
No, less than that. If we are switching then the case to that, to that point, to the indictment order, I mean, we were all here. We heard their case, and they are, of course, all their claims and explanations are based on the proceeding on fiscal liability and the ruling. So are they telling us now that that's not their case and we should not focus on that? Because then, to me, it's a real problem under the treaty. Then.
Mr. Sills.
If I understand the question correctly, we aren't switching anything. The pleading that was submitted on December 8 spoke to the CGR proceeding as it was then. Colombia elected to challenge that proceeding and obtain a stay of all other proceedings while these preliminary objections, and I guess we could call them, well, that where all of their objections would be heard on a preliminary basis. So the case did not move forward. Everybody in the room knows that the case did move forward, that there was a ruling, that the ruling, we say, and I think with complete justification, suffers from extremely grave legal problems and caused further damage to our client. And in the ordinary course, there would have been an amendment to the pleading at this stage. Once we're past these objections, there will be an amendment, and the case will consider additional facts. The record will expand. The measures being challenged will be added to. I think that's hard to dispute. But yes, it is, and we've been consistent on this since this was filed. There is no switch. We challenged what had happened at the time. The RFA does speak as of December 8th, 2019. And that's what was challenged by Colombia. But will this be the shape of the case for all time? No, because the CGR case has moved on with what I have to say is this absurd decision imposing $750 million in damage jointly and severally without even purporting to link any act or omission of my clients to any item of damage, and then hanging the label gross negligence on it, when what they're talking about might be generously construed as a simple breach of contract. But that's all for the future. I think the key point is Colombia jumped the gun. They've chosen to attack the pleading as it was then, and we are defending it as it was then. And once we're past this, of course, we'll amend the case. We're not going to go forward on a pleading. I wouldn't say it's been overtaken by events, because the reputational harm remains, and it will remain an element of our claim, but there will be other elements of the claim. And it's hardly a surprise to anyone in this room that claims are expanded and amended and supplemented as time moves on and as the case moves forward.
Thank you. Can we move on? So I'll turn now to Professor Coyne for his questions.
Thank you, Mr. President. Allow me to make a linguistic comment first. So, because in the first procedural order, it was mentioned that English and Spanish are the procedural languages of the arbitration and have equal dignity. Nevertheless, the same procedural order indicated that the hearings will be mainly occur in English. So this is the reason why I'm prevented to use my mother tongue. I have, I believe, very, very concrete and specific questions. Some are more related to claimants and another to respondent, but obviously both. I expect comments from both sides for all the questions. I would like to start with the submission by the non-disputed party and the attitude adopted by both sides on this. I think we noticed that both Colombia and the United States are adopting similar interpretations of the treaty now. My first question with regard to this is, when Colombia and the US concluded the treaty, did they have another interpretation in mind? Did they have a different intention when they concluded the treaty of that they invoke today? Yes, please.
Professor Cohen, and I should preface this by saying the linguistic provisions of the procedural order were the subject of extensive discussions among the parties and then, of course, with the tribunal. Everyone would, of course, prefer the language in which he's most comfortable, although I can tell you, as a native English speaker, your English suffers from no disabilities. But that was the deal the parties made, that written submissions could be made in Spanish and these proceedings would be in English, in part because everyone in the room speaks English and not everyone in the room speaks Spanish, but no disrespect was meant to Spanish in any sense. And I know you know that, but it's worth saying.
It's just an invitation to improve language skills, and that's all.
I've heard a rumor that Americans are lagging in that regard. But Professor Cohn, with respect to the question you posed, I don't think we can get into the minds of the drafters of the treaty. And what the Vienna Convention teaches us is that the best indication of what the drafters meant is the language they used. I think that's common ground. And sometimes the drafters of any instrument, a treaty, a contract, come to regret what they said, think there was a drafting gap, hadn't considered a particular issue, and they would wish to change it. The mechanism for changing the treaty is to amend it. But I don't think there's any reason to believe that a submission, and not really on the merits, because the submission of the US is highly abstract, somehow tells us that the treaty means something that its plain words don't indicate. I mean, if the United States were to submit a non-disputing party submission tomorrow that said, in our view, requests for arbitration are valid only if they're printed on blue paper, and Colombia said, yes, we agree with that, we'd be subject to dismissal because ours is printed on white paper. The language of the treaty sets the bounds of of what it means. And not only that, but the way in which that language has been interpreted over the years by scholars, by other tribunals, how language in similar treaties has been construed, and none of that is in the U.S. submission. I have to say, with respect to the U.S., the submission is largely either a recitation of what's in the treaty itself or a series of ipsedixits. And the tribunal, I suppose, could be persuaded by what the U.S. submits. But it's up to the tribunal to weigh that. And the Vienna Convention doesn't say if a non-disputing party, state party, to a treaty makes a submission that binds the tribunal or it binds the world or it's authoritative. It says it shall be taken into account. And when something is taken into account, it gets the weight it deserves. So can we get into the minds of the drafters of the treaty and in effect interview them and say, what did you mean by this? Or would you have taken a position, for example, that denial of justice means a different thing in an administrative than a judicial context? Because that inquiry can't be done now. But I think we can look at how that language in this treaty and other treaties has been interpreted. And I think that's the appropriate inquiry. So that's a very long answer to your simple question. I don't think we can get into their minds. Okay. And I don't think with respect, I don't think that's a useful inquiry. It's what they said, not what they thought. That's the relevant inquiry here.
Yeah, I know the content of the Vienna Convention, the law of treaties. My question was concretely where you believe that there was a change in the position, but you answer my question. Maybe respondents are willing to make any comment on it.
Thank you, Professor Cohen. I just want to tell you that I keep pushing to argue in Spanish. Sometimes I win the battle, sometimes I don't. But it's a well point taken. Thank you. Regarding your question, no, that's the intention of both parties. I mean, it is clear, and the United States, came here under the possibility that they have under the treaty, confirming what they agree with Colombia. And, and this is perfectly fine to do it, not only under the treaty, but also under the Vienna Convention. Thank you.
Okay, thanks both parties. Yes, indeed, it is very important to distinguish between interpretation of treaties and modification of treaties. That's a very important point that one has to take into account. The parties have, in their written comments, discussed about subsequent, I can't pronounce this word, practice and subsequent agreement. That's better. Obviously, you have opposite views on what is one thing and the other. My question is, in order to have a subsequent agreement, is it indispensable to have a single text in which the parties say, our right interpretation of this provision is like that? Is it absolutely indispensable for a subsequent agreement to be concluded in a single instrument?
With regard to a subsequent agreement, I believe the authorities do say yes. So, for example, the ILC report of 2013 says this: the use in Article 31(3)(a) of the VCLT of the word agreement presupposes a single common act by the parties by which they manifest their common understanding regarding the interpretation of the treaty. Now, does it have to be in a single document? Could it be a simultaneous exchange of documents that constitute or purport to constitute an agreement? I think that's given the practical emphasis of the Vienna Convention, I suppose it could be an exchange of documents. And in other public law areas, for example, the exchange of diplomatic notes can constitute an agreement as to the meaning of a treaty. Again, I know this is a particular area of expertise of yours, Professor Cohn, but the exchange of diplomatic notes is a recognized way in which some treaties can be clarified or interpreted. But I think there is no case suggesting that the submission of in effect, an amicus brief can constitute a subsequent agreement. And there, as the International Law Commission quote that I just read suggests, there's no authority for the notion that an agreement can be extracted from those, from a submission like this. Does it all have to be on one piece of paper? I think the answer is no. Can a contract consist of an exchange of documents? Yes, it can. But this is very far afield from that. So I think the abstract question is, does it have to be a single document? No, but does it have to be a single transaction, a single occurrence intended to definitively interpret the treaty? Yes, it does.
Thank you. Any comment from the other side?
The answer is no. We indicated that in our pleadings, and we supported it with authorities, and the explanation is there, Professor. Oh, I'm sorry. I was just saying that the answer is no. From our perspective, we pleaded that precisely that point because claimants are arguing the contrary, and all the explanation and supported authorities are in our submissions.
Okay, thank you. So, in the same vein, do you consider that the parties of the TPA follow a distinct practice from that they invoke today? Is it clear, my question? I can...
with apologies, I'm not quite sure.
Okay, I will try to explain myself better. So you have a treaty concluded by the USA and Colombia. The treaty entered into force. Was there any change in the practice? Because my prior question was with regard to the interpretation, okay? But my next question is with regard to the practice. Did the practice of the parties to the treaty change through the years? Is it better?
Thank you. I think the only evidence of that would be claims, claims brought under the treaty by investors here, because there's no occasion for proceedings between the US and Colombia, although the treaty does have state-to-state provisions in it. And so if either Colombia or the US sought a definitive interpretation of the treaty, they could invoke that procedure, and they have not done so. And I think just as some treaties have a very specific mechanism for states to secure interpretation, as NAFTA at least did, which could be invoked. But I think writing opinions is not practice. Submitting amicus briefs or making amicus submissions is not a practice. Practice refers to the real world experience of the treaty being applied to concrete situations. And which is why I think the best guide to what the treaty means following its language, which has to be the starting point, is how have tribunals interpreted and applied the treaty in practice. And here there isn't, I mean, though Colombia has a robust docket of investor state claims, only a few of them involve this particular treaty. There are other treaties with a common origin or a common language. The U.S., as we discussed this afternoon, one of the provisions in dispute here has its origins in the United States model BIT. And so it's appropriate, I think, to look to that to see what light it can shed on the meaning of the treaty language there, administrative, adjudicatory. But a practice, I think common understanding means how has the treaty been dealt with in actual concrete practices, disputes. And then secondarily, how have similar or identical treaties been dealt with in addition, all the non-disputing submissions here that Colombia points to, some of which have been rejected by the tribunals that heard them, were submissions by the U.S. in cases against Colombia. There's nothing ever been submitted by a Colombian investor or by Colombia in a claim by a Colombian investor against the United States. And so far as I'm aware, there have been no such cases. So I think when we think of a common practice, the raw material of a common practice just isn't here. But again, I mean, we discussed at some length the decisions of tribunals either rejecting essentially identical submissions by the U.S. on a non-disputing party basis or accepting parts of them. But the notion that that would somehow establish a common practice, I think is not correct under the Vienna Convention or under the common understanding of what a practice is.
Thank you. Any comment from the respondent?
Thank you, Professor Cohen. We submit that there is a common practice. That practice hasn't changed. We explained it in our submissions, and also today you heard our position in that regard. So yes, the contracting states have been consistent, with the practice on these provisions. That no change. Thanks.
Okay. Now I have another question, which probably would be better to be answered by the respondent first. Is there a possibility to cure jurisdictional deficiencies on of the notice of arbitration later on? Is it clear, my question?
The category answer is no. I mean, that you have to have the notice of arbitration at the time that, going back to the requirements of the treaty, under that notice of arbitration, you will have to establish, the breach and the harm that arises out of that breach. And that is why this treaty, as some other treaties of the United States with other countries, such as NAFTA, they have those requirements, that you need to demonstrate the breach and the harm that arises out of the breach by the time that you submit the notice of arbitration.
Claimants, maybe any comment?
I put to one side the fact that we believe that the RFA does not require It's on. Assuming for the moment, Professor Cohn, that there is a jurisdictional defect here, there is ample authority that a jurisdictional defect can be cured. And we discussed some of those cases in our presentation this afternoon. So, for example, in the Coppice case, which is actually cited by Colombia here, the tribunal actually said nothing in the DR CAFTA, which I think it's common ground, is a very similar treaty to the U.S.-Colombia TPA, that jurisdictional allegations could be supplemented and amended. The same was true of the statements of the tribunal in PACRIM. So the answer is it's not categorical, and it depends upon the particular pleading. It depends on what cure might be suggested. It depends on whether or not there's really any point. So, for example, dismissing a claim just so that it could be refiled with a cured jurisdictional objection would make no sense. So I think there is ample precedent for taking a practical and not hyper-technical and formalistic view and allowing clarification. The quotes from decisions, and again, that we had earlier, and I apologize, I don't have the particular quotations before me, but I know in our presentation this afternoon, we discussed a number of those cases, some from very distinguished tribunals and leading authorities in our field, making it clear that there could be that jurisdictional objections that were jurisdictional allegations that were determined to be defective could be corrected, supplemented, or amended. And I do recall that one of those was authored by Mr. Viter, and I apologize. It's been a long day and I don't have the name of the case in mind.
Thank you very much, Mr. President. I wouldn't like to abuse of my time, but I have... Yes, I can. With your permission, okay. Go ahead. When the alleged investment by claimants terminated, if it finished at one moment in time, it finished.
The work on under the contract, the investment, that work terminated in about 2018 when the refinery was up and running as it is today. Reficar has still not delivered the contractual closeout documents that are required by the contract, but there is no ongoing work by the claimants on, sorry, but it is, I mean, the contract is still open. And since the contract is an element of the investment, I think there's no simple answer. I mean, if the question is when did the actual work, the compensated work stop, the answer would be 2018, or perhaps early in 2019.
Any comment from the respondent side?
No, we don't have any further comments. Thanks.
Thank you. My last question, Mr. President, will be
Go on.
what is the concrete difference? I would like to know the concrete difference of the rights invoked by claimants within the Colombian procedures and the rights invoked here. Concretely, which are the rights that are defended within Colombian procedures, and the difference with this, with the rights that are invoked here before this arbitral tribunal?
Well, it's a difficult question to answer briefly, but to begin with, the source of the rights is different. So the treaty, for example, doesn't say due process under the Colombian Constitution. One of the rights that was invoked in the proceedings before the RFA was filed, before the CGR itself. So fair and equitable treatment is just different from due process under the Colombian Constitution. There we referred to Colombian cases, to Colombian jurisprudence, to, and for that matter, Colombian procedures. So the source of the right is different, and the contours of the rights are different. Is there, can the same conduct violate both Colombian law and international law? Of course. But it's certainly the case that in the first tutela, it invoked Colombian law and rights under Colombian law that are distinct from the rights under international law. Does Colombian law, for example, guarantee national treatment? So far as I know, and I'm not a Colombian lawyer, it does not. There's no guarantee in Colombian law that investors from other countries will be treated no less well than Colombian investors. Whereas that comes from a bedrock principle of investment law, the guarantee of national treatment. And it's a broad question, Professor Cohn, and we would have to lay the record in the CGR proceeding alongside the record here. But I think there's a concrete example of rights that are invoked in this proceeding, that is the right to national treatment, that, so far as I'm aware, has no place in Colombian law. Colombia does not have a provision that guarantees to investors from the United States or any other country, so far as I'm aware, rights, the right to national treatment. And the claimants were scrupulous in the limited instances where they resorted to the Colombian courts to reserve their rights to seek relief under international law in this proceeding. Is some of the conduct complained of here conduct that was or could have been complained of in Colombia? The answer is yes, but I don't think it's a startling proposition to say that similar wrong acts can give rise to rights under different legal regimes. And But some of the wrongful acts are entirely distinct, and the national treatment point that I just made, I think, is a good example of that. They're different, are they? I don't think they are different. Their sources are different. The acts that create liability are different. The remedies are different. So, for example, could the Colombian courts conceivably grant relief as a matter of Colombian law for violation of Colombian law that would go beyond the relief that the treaty allows? The answer is yes. So the elements of a claim, the proof of the claim, the relief that can be granted for violation of a particular right under these two different legal regimes, they are distinct.
Thank you.
Professor Cohen, I'm sorry for the interruption, but there was one clarification that I'd like to offer on your previous question, if I may.
Of course, yes.
In your question, and just to remind the parties here present what the question was that I'll be addressing on the supplementation, is your question about when the investment ended or terminated. I wanted to make sure that we were clear. Mr. Sills was discussing the scope of work of when the work on the contract ended in 2018. However, the investment that the claimants have continues. And so the investment that they made regarding the office, the employees, and the investment generally that they had in Colombia, the local Colombian branch, if you will, that we discussed in our presentation papers still exists of PCIB. I mean, it's that investment continues. And I just wanted to make sure that the record was clear on that point, Your Honor. Your Honor, excuse me. Professor Cohen.
Okay, so if I understand, your proposition is that it continues.
Correct.
It's an ongoing investment, according to you.
That's correct.
Okay. Well, I wonder whether the respondent is willing to make any comment.
Thank you, Professor Cohen. There are not assets in Colombia, and they finished working under the contract. Of course, we say that contract is not an investment. But in any event, the execution of the contract has ended, and there are not assets. The performance of the services have ended, and there are not assets in Colombia.
Okay.
And I should say this is yet another disputed issue of fact that cannot be resolved now. But I should note, as we mentioned earlier, it's the work has finished. The refinery is there. The contract has not been. The closing documents have not been delivered by Reficar as they're obligated to under the contract, and they have in fact commenced proceedings. So I think it's fair to say it's a mixed question of law and fact whether the investment still continues. We say it does. They say it doesn't. But it's yet another question that can't be resolved in this procedural context.
Okay, thank you very much. No further questions, Mr. President.
Before we close the session, I have just one question. And I'd like to make a reference first to Claimants, slide number 33. And also respondents 153. 153. Basically, what we have here, it's along the lines of your clarification. The respondent claims that there was no investment risk and therefore no investment. Okay? I do not want to go into the details. This is something we'll decide later. But in your slide 33, the highlighted portion says claimants contracted with Reficar a Colombia-owned enterprise to provide project management services in connection with the construction and expansion of an oil refinery owned by Colombia to supply environmentally clean motor fuels to meet Colombian demand. That's this portion is part of my question now. In doing so, claimants invested significant amounts of time, capital, personnel, and labor in Colombian territory. This slide is also slide 96 in your presentation, but that's the same. Then I go to slide number 3 of respondent, which says it's a summary of the services contract and says remuneration structure, full reimbursement of costs plus profit. Okay? And the question is, how I draw the line to segregate what is investment and what is reimbursement of a services contract. How? Because you have just clarified that the contract is still open. It was not closed. And you have personnel there. The investment, you told us the investment is there. And then respondent says, no, you don't have anything. You don't have assets. This is something that we'll decide at the appropriate time. But my question is, if you get under the service contract the reimbursement of amounts plus profit or costs plus profit, how you draw the line to say that there's a portion which is investment made by me? That's what you're saying. And there's slide 33, which is paragraph 29 of the request for arbitration. Do you understand my point?
I do. Sorry, we do, and you know, I put to one side, Mr. President, you know, the notion that what Colombia describes as investment risk is a necessary element of an investment when the treaty lists it disjunctively and common practice lists it disjunctively. You know, if I build a factory in Colombia to provide a particular good to Colombia, and the government is the only consumer of that good, and I build the factory and I hire labor and I buy raw materials and I sell them to the Colombian government at an agreed price, I don't think anyone would say I haven't made an investment in Colombia, even though Colombia would now say, well, you took no risk. You know, you agreed to do this on a cost plus basis. But I think what your question highlights is how fact intensive this decision is.
Let me just add something. I'm not looking with this question, the current situation today, as it was in the past. You had reimbursement and investment. I'm looking to that point there.
And I understand, but I think at the one extreme, you have a simple contract to sell goods or services. Is that an investment? I think it's common ground that it's not. And at the other extreme, you acquire real estate, put in an elaborate manufacturing facility, and hire workers and pay taxes. And everyone would agree that is an investment. And there's a spectrum. And I think your question asks, where does one draw the line along that spectrum? And I think the answer is, and as the explanatory notes to the treaty make clear, it's a complex question of law and fact, where to draw that line, and you have to draw it with reference to the particular investment. But I have to say that as our slide, this was a confidential slide, as our slide 34 made clear,
I did not mention it
Right.
because
I
for
understand.
obvious reasons.
but we do not at all agree with or endorse Colombia's graphic on page 153 of the contract. There was, even in the terms they set out, there was investment risk here. And as the check case that we cited and discussed makes clear, it's somewhat remarkable that Colombia, Reficar's parent, Colombia, is now trying to extract from our clients 300% of the revenues that were recognized there, to say, well, you faced no risk. And any long-term investment in a foreign country is an investment within the meaning of the treaty. But I think this is yet another issue, because where one draws the line with respect to any particular investment or claimed investment is going to depend on the particular facts of the investment, the particular context in which it's made, the agreements that govern it, the real world experience of how that investment was treated. And it's again a question of fact. And our slide 34, and I thank you for leaving it as it is, but that slide makes it clear that there was risk. We say it's more than ample risk to satisfy that condition, assuming that risk is required for an investment, as opposed to being one of the elements listed in the treaty for an investment. Investment is drafted in a very broad sense in the TPA, and that has to be taken account of. But it's simply Colombia's challenge to the investment status of our investment is not one that can be resolved at this point.
Thank you. Any comments?
Mr. President, we submit to you that this is precisely the question that this tribunal needs to decide right now. It's a jurisdictional question, so it is before you. You can decide that question just by looking at the contract. The contract is an exhibit in the case. We went through those slides. We have explained the formulation of payments, to all their services that they render under the contract, and we still don't see the investment. They got every penny they charge. They got it back, and we move on. So anyway.
Yeah, I know that this is something that we have to decide, but it's also useful to have the parties' views on certain aspects, especially this one, because I'm moving from today's date to the past. What happened when everything was active, the contract and the joint venture? That's it. Okay, I have the information. I thank you very much. Well, that was just one question. Any more questions? John? Any matters you would like to address before we adjourn, or we can go home?
Nothing for the claimants, Mr. President.
Okay.
Nothing from the respondent.
Okay.
Thank you.
Again, I would like to thank you very, very much for this long day. It was excellent to be back and be here in this room, sharing your views, our questions, your presentations with those who unfortunately, for sanitary reasons, could not be here, but followed us by the platform. So I thank you very, very much. I'm delighted to be here. And tomorrow at 10:30, we start an hour and a half later than today. And we should be closed by 1 o'clock. Okay?
Okay, thank
you.
you. Good night to everybody.